Part 2, Chapter 6 of A Key to Uncle Tom's Cabin, by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. Recording by Catherine. Chapter 6. Protective Acts with Regard to Food and Raiment, Labor, etc. Illustrative Drama of Tom vs. Legree under the Law of South Carolina. Separation of Parent and Child. Having finished the consideration of the laws which protect the life and limb of the slave, the reader may feel a curiosity to know something of the provisions by which he is protected in regard to food and clothing, and from the exactions of excessive labor. It is true, there are multitudes of men in the northern states who would say at once that such enactments, on the very face of them, must be superfluous and absurd. What, they say, are not the slaves property? And is it likely that any man will impair the market value of his own property by not giving them sufficient food or clothing, or by overworking them? This process of reasoning appears to have been less convincing to the legislators of the southern states than to gentlemen generally at the North, since, as Judge Taylor says, the Act of 1786, Iredell's Revisal, page 588, does, in the preamble, recognize the fact that many persons, by cruel treatment of their slaves, cause them to commit crimes for which they are executed. And the judge further explains this language by saying, the cruel treatment here alluded to must consist in withholding from them the necessities of life, and the crimes thus resulting are such as are necessary to furnish them with food and raiment. The state of South Carolina, in the Act of 1740, see Stroud's sketch, page 28, had a section with the following language in its preamble. Whereas many owners of slaves, and others who have the care, management, and overseeing of slaves, do confine them so closely to hard labor, that they have not sufficient time for natural rest. And the law goes on to enact that the slave shall not work more than 15 hours a day in summer, and 14 in winter. Judge Stroud makes it appear that in 3 of the slave states the time allotted for work to convicts in prison, whose punishment is to consist in hard labor, cannot exceed 10 hours, even in the summer months. This was the Protective Act of South Carolina, designed to reform the abusive practices of masters who confined their slaves so closely that they had not time for natural rest. What sort of habits of thought do these humane provisions show in the makers of them? In order to protect the slave from what they consider undue exaction, they humanely provide that he shall be obliged to work only 4 or 5 hours longer than the convicts in the prison of the neighboring state. In the island of Jamaica, besides many holidays which were accorded by law to the slave, 10 hours a day was the extent to which he was compelled by law ordinarily to work. See Stroud, page 29. With regard to protective acts concerning food and clothing, Judge Stroud gives the following example from the legislation of South Carolina. The author gives it as quoted by Stroud, page 32. In case any person, etc., who shall be the owner, or who shall have the care, government, or charge of any slave or slaves, shall deny, neglect, or refuse to allow such slave or slaves, etc., sufficient clothing, covering, or food, it shall and may be lawful for any person or persons, on behalf of such slave or slaves, to make complaint to the next neighboring justice in the parish where such slave or slaves live or are usually employed. And the said justice shall summon the party against whom such complaint shall be made, and shall inquire of, hear, and determine the same. And if the said justice shall find the said complaint to be true, or that such person will not exculpate or clear himself from the charge, by his or her own oath, which such person shall be at liberty to do in all cases where positive proof is not given of the offence, such justice shall and may make such orders upon the same, for the relief of such slave or slaves, as he in his discretion shall think fit, and shall and may set and impose a fine or penalty on any person who shall offend in the premises, in any sum not exceeding £20 current money for each offence. 2 Breviards Digest 241. Also Cobb's Digest 227. A similar law obtains in Louisiana. Revised Statutes 1852, page 557, section 166. Now, would not anybody think, from the virtuous solemnity and gravity of this act, that it was intended in some way to amount to something? Let us give a little sketch to show how much it does amount to. Angelina Grimke Veld, sister of Sarah Grimke, before quoted, gives the following account of the situation of slaves on plantations. And here let me say that the treatment of plantation slaves cannot be fully known except by the poor sufferers themselves and their drivers and overseers. In a multitude of instances, even the master can know very little of the actual condition of his own field slaves, and his wife and daughters far less. A few facts concerning my own family will show this. Our permanent residence was in Charleston. Our country seat, Belmont, was 200 miles distant, in the northwestern part of the state, where for some years our family spent a few months annually. Our plantation was 3 miles from this family mansion. There all the field slaves lived and worked. Occasionally, once a month perhaps, some of the family would ride over to the plantation, but I never visited the fields where the slaves were at work, and knew almost nothing of their condition. But this I do know, that the overseers who had charge of them were generally unprincipled and intemperate men. But I rejoice to know that the general treatment of slaves in that region of country was far milder than on the plantations in the lower country. Throughout all the eastern and middle portions of the state, the planters very rarely reside permanently on their plantations. They have almost invariably 2 residences, and spend less than half the year on their estates. Even while spending a few months on them, politics, field sports, races, speculations, journeys, visits, company, literary pursuits, etc., absorb so much of their time that they must, to a considerable extent, take the condition of their slaves on trust, from the reports of their overseers. I make this statement because these slaveholders, the wealthier class, are, I believe, almost the only ones who visit the North with their families, and Northern opinions of slavery are based chiefly on their testimony. With regard to overseers, Miss Grimke's testimony is further borne out by the universal acknowledgment of Southern owners. A description of this class of beings is furnished by Mr. Wirt in his Life of Patrick Henry, page 34. Last and lowest, he says, of different classes in society, a feculum of beings called overseers, a most abject, degraded, unprincipled race. Now, suppose, while the master is in Charleston, enjoying literary leisure, the slaves on some Belmont or other plantation, getting tired of being hungry and cold, form themselves into a committee of the whole to see what is to be done. A broad-shouldered, courageous fellow, whom we will call Tom, declares it is too bad, and he won't stand it any longer, and having by some means become acquainted with this benevolent protective act, resolves to make an appeal to the horns of this legislative altar. Tom talks stoutly, having just been brought on to the place, and been used to better quarters elsewhere. The women and children perhaps admire, but the venerable elders of the plantation, Sambo, Cudge, Pomp, and old Aunt Dinah, tell him he better mind himself, and keep clar of that there. Tom, being young and progressive, does not regard these conservative maxims. He is determined that if there is such a thing as justice to be got, he will have it. After considerable research, he finds some white man in the neighborhood verdant enough to enter the complaint for him. Master Legree finds himself one sunshiny pleasant morning walked off to some Justice Dogberry's to answer to the charge of not giving his niggers enough to eat and wear. We will call the infatuated white man who has undertaken this fool's errand Master Shallow. Let us imagine a scene. Legree, standing carelessly with his hands in his pockets, rolling a quid of tobacco in his mouth. Justice Dogberry, seated in all the majesty of law, reinforced by a decanter of whisky and some tumblers, intended to assist in illuminating the intellect in such obscure cases. Justice Dogberry. Come, gentlemen, take a little something to begin with. Mr. Legree, sit down. Sit down, what's your name? Mr. Shallow. Mr. Legree and Mr. Shallow each sit down and take their tumbler of whisky and water. After some little conversation, the justice introduces the business as follows. Now about this nigger business. Gentlemen, you know the act of, where the deuce is that act? Fumbling an old law book. How plague did you ever hear of that act, Shallow? I'm sure I'm forgot all about it. Oh, here it is. Well, Mr. Shallow, the act says you must make proof, you observe. Mr. Shallow, stuttering and hesitating. Good land! Why, don't everybody see that the mere niggers are most starved? Only see how ragged they are. Justice. I can't say as I have observed it particular. Seem to be very well contented. Shallow, eagerly. But just ask Pomp or Sambo or Dinah or Tom. Justice Dogberry, with dignity. I'm astonished at you, Mr. Shallow. You think of producing negro testimony. I hope I know the law better than that. We must have direct proof, you know. Shallow is posed. Legree significantly takes another tumbler of whisky and water, and Justice Dogberry gives a long ahem. After a few moments, the justice speaks. Well, after all, I suppose, Mr. Legree, you wouldn't have any objections to swearing off. That settles it all, you know. As swearing is what Mr. Legree is rather more accustomed to do than anything else that could be named, a more appropriate termination of the affair could not be suggested, and he swears accordingly to any extent and with any fullness and variety of oath that could be desired, and thus the little affair terminates. But it does not terminate thus for Tom or Sambo, Dinah, or any others who have been alluded to for authority. What will happen to them when Mr. Legree comes home had better be left to conjecture. It is claimed by the author of certain paragraphs quoted at the commencement of Part II that there exist in Louisiana ample protective acts to prevent the separation of young children from their mothers. This writer appears to be in the enjoyment of an amiable ignorance and unsophisticated innocence with regards to the workings of human society generally, which is on the whole rather refreshing. For on a certain incident in Uncle Tom's Cabin, which represented Cassie's little daughter having been sold from her, he makes the following naive remark. Now, the reader will perhaps be surprised to know that such an incident as the sale of Cassie apart from Eliza, upon which the whole interest of the foregoing narrative hinges, never could have taken place in Louisiana, and that the bill of sale for Eliza would not have been worth the paper it was written on. Observe, George Shelby states that Eliza was 8 or 9 years old at the time his father purchased her in New Orleans. Let us again look at the statute book of Louisiana. In the Code Noir we find it set down that every person is expressly prohibited from selling separately from their mothers the children who shall not have attained the full age of 10 years. And this humane provision is strengthened by a statute, one clause of which runs as follows: Be it further enacted, that if any person or persons shall sell the mother of any slave child or children under the age of 10 years, separate from said child or children, or shall, the mother living, sell any slave child or children of 10 years of age or under, separate from said mother, Such person or persons shall incur the penalty of the 6th section of this act. The penalty is a fine of not less than $1,000 nor more than $2,000, and imprisonment in the public jail for a period of not less than 6 months nor more than 1 year. Vide Acts of Louisiana, First Session, 9th Legislature, 1828-29, number 24, section 16. Revised Statutes, 1852, page 550, section 143. What a charming freshness of nature is suggested by this assertion! A thing could not have happened in a certain state, because there was a law against it. Has there not been for 2 years a law forbidding to succor fugitives or to hinder their arrest? And has not this thing been done thousands of times in all of the northern states? And is not it more and more likely to be done every year? What is a law against the whole public sentiment of society? And will anybody venture to say that the public sentiment of Louisiana practically goes against separation of families? But let us examine a case more minutely, remembering the bearing on it of 2 great foundation principles of slave jurisprudence, namely, that the slave cannot bring a suit in any case, except in a suit for personal freedom, and this in some states must be brought by a guardian, and that a slave cannot bear testimony in any case in which whites are implicated. Suppose Butler wants to sell Cassie's child of 9 years. There is a statute forbidding to sell under 10 years. What is Cassie to do? She cannot bring suit. Will the state prosecute? Suppose it does. What then? Butler says the child is 10 years old. If he pleases, he will say she is 10 and a half, or 11. What is Cassie to do? She cannot testify. Besides, she is utterly in Butler's power. He may tell her that if she offers to stir in the affair, he will whip the child within an inch of its life. And she knows he can do it, and that there is no help for it. He may lock her up in a dungeon, sell her on to a distant plantation, or do any other despotic thing he chooses, and there is nobody to say nay. How much does the protective statute amount to for Cassie? It may be very well as a piece of advice to the public, or as a decorous expression of opinion, but one might as well try to stop the current of the Mississippi with a bulrush as the tide of trade in human beings with such a regulation. We think that by this time the reader will agree with us that the less the defenders of slavery say about protective statutes, the better. End of Part 2, Chapter 6. Protective Acts with regard to food and raiment, labor, etc. Part 2, Chapter 7 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Chapter 7. The Execution of Justice. State versus Eliza Rowand. The aegis of protection to the slave's life. We cannot but regard the fact of this trial as a salutary occurrence. Charleston Courier. Having given some account of what sort of statutes are to be found on the law books of slavery, the reader will hardly be satisfied without knowing what sort of trials are held under them. We will quote one specimen of a trial, reported in the Charleston Courier of May 6th, 1847. The Charleston Courier is one of the leading papers of South Carolina, and the case is reported with the utmost apparent innocence that there was anything about the trial that could reflect in the least of the character of the state for the utmost legal impartiality. In fact, the Charleston Courier ushers it into public view with the following flourish of trumpets, as something which is forever to confound those who say that South Carolina does not protect the life of the slave. The trial for murder. Our community was deeply interested and excited yesterday by a case of great importance and also of entire novelty in our jurisprudence. It was the trial of a lady of respectable family, and the mother of a large family, charged with the murder of her own or her husband's slave. The courthouse was thronged with spectators of the exciting drama, who remained, with unabated interest and undiminished numbers, until the verdict was rendered acquitting the prisoner. We cannot but regard the fact of this trial as a salutary, although in itself lamentable occurrence, as it will show to the world that however panoplied in station and wealth, and although challenging those sympathies which are the right and inheritance of the female sex, no one will be suffered in this community to escape the most sifting scrutiny, at the risk of even an ignominious death, who stands charged with the suspicion of murdering a slave, to whose life our law now extends the aegis of protection, in the same manner as it does to that of the white man, save only in the character of the evidence necessary for conviction or defense. While evil-disposed persons at home are thus taught that they may expect rigorous trial and condign punishment, when, actuated by malignant passions, they invade the life of the humble slave, the enemies of our domestic institution abroad will find, their calumnies to the contrary notwithstanding, that we are resolved in this particular to do the full measure of our duty to the laws of humanity. We subjoin a report of the case. The proceedings of the trial are thus given. Trial for the murder of a slave. State versus Eliza Rowand, Spring Term, May 5, 1847. Tried before His Honor Judge O'Neill. The prisoner was brought to the bar and arraigned, attended by her husband and mother, and humanely supported during the trying scene by the Sheriff J. B. Irving, Esquire. On her arraignment she pleaded not guilty, and for her trial placed herself upon God and her country. After challenging John M. Diaz, James Bancroft, H. B. Arbers, J. C. Beckman, E. R. Cowperthwaite, Parker J. Holland, Moses D. Hyams, Thomas Glaze, John Lawrence, B. Archer, J. S. Addison, B. Pay Colburn, B. M. Jenkins, Carl Hausman, George Jackson, and Joseph Koppenberg, the prisoner accepted the subjoined panel, who were duly sworn and charged with the case. 1. John L. Noel, foreman. 2. Elias Wilden. 3. Jesse Coward. 4. Effington Wagner. 5. William Whaley. 6. James Colbert. 7. R. L. Baker. 8. S. Wiley. 9. W. S. Chisholm. 10. T. M. Howard. 11. John Bickley. 12. John Y. Stock. The following was the indictment on which the prisoner was arraigned for trial. The State versus Eliza Rowand. Indictment for murder of a slave. State of South Carolina, to wit, Charleston District. At the Court of General Sessions, begun and holden in and for the District of Charleston in the State of South Carolina, at Charleston, in the District and State aforesaid, on Monday, the 3rd day of May, in the year of our Lord, 1847. The jurors of and for the District of Charleston, aforesaid, in the State of South Carolina, aforesaid, upon their oaths present, that Eliza Rowand, the wife of Robert Rowand, Esquire, not having the fear of God before her eyes, but being moved and seduced by the instigation of the devil, on the 6th day of January, in the year of our Lord 1847, with force and arms, at Charleston, in the District of Charleston, the State aforesaid, in and upon a certain female slave of the said Robert Rowand, named Maria, in the peace of God, and of the said State, then and there being, feloniously, maliciously, wilfully, deliberately, and of her malice aforethought, did make an assault, and that a certain other slave of the said Robert Rowand, named Richard, then and there being then and there in the presence and by the command of the said Eliza Rowand, with a certain piece of wood, which he the said Richard in both his hands then and there had and held, the said Maria did beat and strike, in and upon the head of her, the said Maria, then and there giving to her the said Maria, by such striking and beating as aforesaid, with a piece of wood aforesaid, divers mortal bruises, on the top, back, and sides of the head of her the said Maria, of which several mortal bruises she, the said Maria, then and there instantly died. And that the said Eliza Rowand was then and there present, and then and there feloniously, maliciously, wilfully, deliberately, and of her malice aforethought, did order, command, and require the said slave named Richard, the murder and felony aforesaid, in manner and form aforesaid, to do and commit. And as the jurors aforesaid upon their oaths aforesaid do say, that the said Eliza Rowand, her the said slave named Maria, in the manner and by the means aforesaid, feloniously, maliciously, wilfully, deliberately, and of her malice aforethought, did kill and murder, against the form of the act of the General Assembly of the said state in such case made and provided, and against the peace and dignity of the same state aforesaid. And the jurors aforesaid, upon their oaths aforesaid, do further present that the said Eliza Rowand, not having the fear of God before her eyes, but being moved and seduced by the instigation of the devil, on the 6th day of January, in the year of our Lord 1847, with force and arms, at Charleston, in the district of Charleston, and state aforesaid, in and upon a certain other female slave of Robert Rowand, named Maria, in the peace of God, and of the said state, then and there being, feloniously, maliciously, wilfully, deliberately, and of her malice aforethought, did make an assault, and that the said Eliza Rowand, with a certain piece of wood, which she, the said Eliza Rowand, in both her hands then and there had and held, her the said last mentioned slave, named Maria, did then and there strike and beat in and upon the head of her, the said Maria, then and there giving to her, the said Maria, by such striking and beating aforesaid, with a piece of wood aforesaid, divers mortal bruises, on the top, back, and side of the head, of her the said Maria, of which said several mortal bruises she, the said Maria, then and there instantly died. And so the jurors aforesaid upon their oaths aforesaid do say, that the said Eliza Rowand, her the said last mentioned slave named Maria, in the manner and by the means last mentioned, feloniously, maliciously, wilfully, deliberately, and of her malice aforethought, did kill and murder, against the form of the act of the General Assembly of the said state in such case made and provided, and against the peace and dignity of the same state aforesaid. H. Bailey, Attorney General. As some of our readers may not have been in the habit of endeavoring to extract anything like common sense or information from documents so very concisely and luminously worded, the author will just state her own opinion that the above document is intended to charge Mrs. Eliza Rowand with having killed her slave Maria in one of two ways, either with beating her on the head with her own hands, or having the same deed performed by proxy, by her slave man Richard. The whole case is now presented. In order to make the reader clearly understand the arguments, it is necessary that he bear in mind that the law of 1740, as we have before shown, punished the murder of the slave only with fine and disfranchisement, while the law of 1821 punishes it with death. On motion on Mr. Pettigrew, the prisoner was allowed to remove from the bar and take her place by her counsel, the judge saying he granted the motion only because the prisoner was a woman, but that no such privilege would have been extended by him to any man. The Attorney General, Henry Bailey, Esquire, then rose and opened the case for the state, in substance as follows. He said that, after months of anxiety and expectation, the curtain had at length risen, and he and the jury were about to bear their part in the sad drama of real life which had so long engrossed the public mind. He and they were called to the discharge of an important, painful, and solemn duty. They were to pass between the prisoner and the state, to take an inquisition of blood. On their decision hung the life or death, the honor or ignominy of the prisoner, Yet he trusted he and they would have the strength and ability to perform their duty faithfully, and whatever might be the result, their consciences would be consoled and quieted by that reflection. He bade the jury pause and reflect on the great sanctions and solemn responsibilities under which they were acting. The constitution of the state invested them with power over all that affected the life and was dear to the family of the unfortunate lady on trial before them. They were charged, too, with the sacred care of the law of the land, and to their solution was submitted one of the most solemn questions ever entrusted to the arbitrament of man. They should pursue a direct and straightforward course, turning neither to the right hand nor to the left, influenced neither by prejudice against the prisoner nor by a morbid sensibility in her behalf. Some of them might practically and personally be strangers to their present duty, but they were all familiar with the laws and must be aware of the responsibilities of jurymen. It was scarcely necessary to tell them that, if evidence fixed guilt on this prisoner, they should not hesitate to record a verdict of guilty, although they should write that verdict in tears of blood. They should let no sickly sentimentality or morbid feeling on the subject of capital punishments deter them from the discharge of their plain and obvious duty. They were to administer, not to make, the law. They were called on to enforce the law by sanctioning the highest duty to God and to their country. If any of them were disturbed with doubts or scruples on this point, he scarcely supposed they would have gone into the jury box. The law had awarded capital punishment as the meet retribution for the crime under investigation, and they were sworn to administer that law. It had, too, the full sanction of Holy Writ. We were there told that the land cannot be cleansed of the blood shed therein, except by the blood of him that shed it. He felt assured, then, that they would be swayed only by a firm resolve to act on this occasion in obedience to the dictates of sound judgments and enlightened consciences. The prisoner, however, had claims on them, as well as the community. She was entitled to a fair and impartial trial. By the wise and humane principles of our law, they were bound to hold the prisoner innocent, and she stood guiltless before them until proved guilty by legal, competent, and satisfactory evidence. Deaf alike to the voice of sickly humanity and heated prejudice, they should proceed to their task with minds perfectly equipoised and impartial. They should weigh the circumstances of the case with a nice and careful hand, and if, by legal evidence, circumstantial and satisfactory, although not positive, guilt be established, they should unhesitatingly, fearlessly, and faithfully record the result of their convictions. He would next call their attention to certain legal distinctions, but would not say a word of the facts. He would leave them to the lips of the witnesses, unaffected by any previous comments of his own. The prisoner stood indicted for the murder of a slave. This was supposed not to be the murder at common law. At least it was not murder by our former statute, but the Act of 1821 had placed the killing of the white man and the black man on the same footing. He here read the Act of 1821, declaring that any person who shall wilfully, deliberately, and maliciously murder a slave shall, on conviction thereof, suffer death without benefit of clergy. The rules applicable to murder at common law were generally applicable, however, to the present case. The inquiries to be made may be reduced to two. 1. Is the party charged guilty of the fact of killing? This must be clearly made out by proof. If she be not guilty of killing, there is an end of the case. 2. The character of that killing, or of the offense. Was it done with malice aforethought? Malice is the essential ingredient of the crime. Where killing takes place, malice is presumed, unless the contrary appear, and this must be gathered from the attending circumstances. Malice is a technical term, importing a different meaning from that conveyed by the same word in common parlance. According to the learned Michael Foster, It consists not in malevolence in particulars. It does not mean hatred to any particular individual, but is general in its import and application. But even killing, with intention to kill, is not always murder. There may be justifiable and excusable homicide, and killing in sudden heat and passion is so modified to manslaughter. Yet there may be murder when there is no ill feeling, nay, perfect indifference to the slain, as in the case of the robber who slays to conceal his crime. Malice aforethought is that depraved feeling of the heart which makes one regardless of social duty and fatally bent on mischief. It is fulfilled by that recklessness of law and human life which is indicated by shooting into a crowd, and thus doing murder on even an unknown object. Such a feeling the law regards as hateful, and visits, in its practical exhibition, with condign punishment, because opposed to the very existence of law and society. One may do fatal mischief without this recklessness, but when the act is done, regardless of consequences, and death ensues, it is murder in the eye of the law. If the facts to be proved in this case should not come up to these requisitions, he implored the jury to acquit the accused, as at once due to law and justice. They should note every fact with scrutinizing eye, and ascertain whether the fatal result proceeded from passing accident or from brooding revenge, which the law stamped with the odious name of malice. He would make no further preliminary remarks, but proceed at once to lay the facts before them from the mouths of the witnesses. Evidence. J. Porteous de Vaux sworn. He is the coroner of Charleston District, held the inquest on the 7th of January last on the body of the deceased slave Maria, the slave of Robert Rowand, at the residence of Mrs. T. C. B., the mother of the prisoner, in Logan Street. The body was found in an outbuilding, a kitchen. It was the body of an old and emaciated person, between 50 and 60 years of age. It was not examined in his presence by physicians. Saw some few scratches about the face. Adjourned to the City Hall. Mrs. Rowan was examined. Her examination was in writing. It was here produced and read as follows. Mrs. Eliza Rowan sworn. Says Maria is her nurse and had misbehaved on yesterday morning. Deponent sent Maria to Mr. Rowan's house to be corrected by Simon. Deponent sent Maria from the house about 7 o'clock a.m. She returned to her about 9 o'clock, came into her chamber. Simon did not come into the chamber at any time previous to the death of Maria. Deponent says Maria fell down in the chamber. Deponent had her seated up by Richard, who was then in the chamber, and Deponent gave Maria some asafoetida. Deponent then left the room. Richard came down and said Maria was dead. Deponent says Richard did not strike Maria, nor did anyone else strike her in Deponent's chamber. Richard left the chamber immediately with Deponent. Maria was about 52 years of age. Deponent sent Maria by Richard to Simon, to Mr. Rowan's house, to be corrected. Mr. Rowan was absent from the city. Maria died about 12 o'clock. Richard and Maria were on good terms. Deponent was in the chamber all the while that Richard and Maria were there together. Eliza Rowand. Sworn to before me this 7th January, 1847. J. P. DeVoe, Coroner, D.C. Witness went to the chamber of prisoner where the death occurred. Saw nothing particular. Some pieces of wood in a box set in the chimney. His attention was called to one piece in particular, 18 inches long, 3 inches wide, and about 1½ inch thick. Did not measure it. The jury of inquest did. It was not a light wood knot. Thinks it was of oak. There was some pine wood and some split oak. Dr. Peter Porcher was called to examine the body professionally, who did so out of witness's presence. Before this witness left the stand, B. F. Hunt, Esquire, one of the counsel for the prisoner, rose and opened the defense before the jury, in substance as follows. He said that the scene before them was a very novel one, and whether for good or evil he would not pretend to prophesy. It was the first time in the history of this state that a lady of good character and respectable connections stood arraigned at the bar, and had been put on trial for her life on facts arising out of her domestic relations to her own slave. It was a spectacle consoling and cheering perhaps to those who owed no goodwill to the institutions of our country, but calculated only to excite pain and regret among ourselves. He would not state a proposition so revolting to humanity as that crime should go unpunished, but judicial interference between the slave and the owner was a matter at once of delicacy and danger. It was the first time he had ever stood between a slave owner and the public prosecutor, and his sensations were anything but pleasant. This is an entirely different case from homicide between equals in society. Subordination is indispensable where slavery exists, and in this there is no new principle involved. The same principle prevails in every country. On shipboard and in the army a large discretion is always left to the superior. Charges by inferiors against their superiors were always to be viewed with great circumspection at least, and especially when the latter are charged with cruelty or crime against subordinates. In the relation of owner and slave there is an absence of the usual motives for murder, and strong inducements against it on the part of the former. Life is usually taken from avarice or passion. The master gains nothing, but loses much, by the death of his slave, and when he takes the life of the latter deliberately, there must be more than ordinary malice to instigate the deed. The policy of altering the old law of 1740, which punished the killing of a slave with fine and political disfranchisement, was more than doubtful. It was the law of our colonial ancestors, it conformed to their policy and was approved by their wisdom, and it continued undisturbed by their posterity until the year 1821. It was engrafted on our policy in counteraction of the schemes and machinations, or in deference to the clamors of those who formed plans for our improvement, although not interested in nor understanding our institutions, and whose interference led to the tragedy of 1822. He here adverted to the views of Chancellor Harper on this subject, who, in his able and philosophical memoir on slavery, said, "It is a somewhat singular fact that when there existed in our state no law for punishing the murder of a slave other than a pecuniary fine, there were, I will venture to say, at least 10 murders of free men for one murder of a slave. Yet it is supposed that they were less protected than their masters." The change was made in subserviency to the opinions and clamor of others who were utterly incompetent to form an opinion on the subject, and a wise act is seldom the result of legislation in this spirit. From the fact I have stated, it is plain they need less protection. Juries are therefore less willing to convict, and it may sometimes happen that the guilty will escape all punishment. Security is one of the compensations of their humble position. We challenge the comparison, that with us there have been fewer murders of slaves than of parents, children, apprentices, and other murders, cruel and unnatural, in society where slavery does not exist. Such was the opinion of Chancellor Harper on this subject, who had profoundly studied it, and whose views had been extensively read on this continent and in Europe. Fortunately, the jury, he said, were of the country, acquainted with our policy and practice, composed of men too independent and honorable to be led astray by the noise and clamor out of doors. All was now as it should be. At least, a court of justice had assembled, to which his client had fled for refuge and safety. Its threshold was sacred, no profane clamors entered there, but legal investigation was had of facts, derived from the testimony of sworn witnesses, and this should teach the community to shut their bosoms against sickly humanity, and their ears to imaginary tales of blood and horror, the food of a depraved appetite. He warned the jury that they were to listen to no testimony but that of free white persons, given on oath in open court. They were to imagine none that came not from them. It was for this that they were selected, their intelligence putting them beyond the influence of unfounded accusations, unsustained by legal proof, of legends of aggravated cruelty, founded on the evidence of negroes, and arising from weak and wicked falsehoods. Were slaves permitted to testify against their owner, it would cut the cord that unites them in peace and harmony, and enable them to sacrifice their masters to their ill will or revenge. Whole crews had often leagued to charge captains of vessels with foulest murder, but judicial trial had exposed the falsehood. Truth had been distorted in this case, and murder manufactured out of what was nothing more than ordinary domestic discipline. Chastisement must be inflicted until subordination is produced, and the extent of the punishment is not to be judged by one's neighbors, but by himself. The event in this case has been unfortunate and sad, but there was no motive for the taking of life. There is no pecuniary interest in the owner to destroy his slave. The murder of his slave can only happen from ferocious passions of the master, filling his own bosom with anguish and contrition. This case has no other basis but unfounded rumor, commonly believed, on evidence that will not venture here, the offspring of that passion and depravity which make up falsehood. The hope of freedom, of change of owners, revenge, are all motives with slave witnesses to malign their owners, and to credit such testimony would be to dissolve human society. Where deliberate, wilful, and malicious murder is done, whether by male or female, the retribution of the law is a debt to God and man, but the jury should beware lest it fall upon the innocent. The offence charged was not strictly murder at common law. The Act of 1740 was founded on the practical good sense of our old planters, and its spirit still prevails. The Act of 1821 is, by its terms, an act only to increase the punishment of persons convicting of murdering a slave, and this is a refinement in humanity of doubtful policy. But by the Act of 1821, the murder must be wilful, deliberate, and malicious, and when punishment is due to the slave, the master must not be held to strict account for going an inch beyond the mark. Whether for doing so he shall be a felon is a question for the jury to solve. The master must conquer a refractory slave, and deliberation, so as to render clear the existence of malice, is necessary to bring the master within the provision of the act. He bade the jury remember the words of him who spake as never man spake. Let him that has never sinned throw the first stone. They as masters might regret excesses to which they have themselves carried punishment. He was not at all surprised at the course of the Attorney General. It was his wont to treat every case with perfect fairness. He, Colonel H., agreed that the inquiry should be 1. Into the fact of the death. 2. The character or motive of the act. The examination of the prisoner showed conclusively that the slave died a natural death and not from personal violence. She was chastised with a lawful weapon, was in weak health, nervous, made angry by her punishment, excited. The story was then a plain one. The community had been misled by the creations of imagination or the statements of interested slaves. The negro came into her mistress's chamber, fell on the floor, medicine was given her, it was supposed she was asleep, but she slept the sleep of death. To show the wisdom and policy of the old Act of 1740, this indictment is under both acts, the punishment only altered by that of 1821. He urged that a case like this was not murder at common law, nor is the same evidence applicable at common law. There, murder was presumed from killing, not so in the case of a slave. The Act of 1740 permits a master, when his slave is killed in his presence, there being no other white person present, to exculpate himself by his own oath, and this exculpation is complete unless clearly contravened by the evidence of 2 white witnesses. This is exactly what the prisoner has done. She has, as the law permits, by calling on God, exculpated herself, and her oath is good, at least against the slander of her own slaves. Which, then, should prevail, the clamors of others, or the policy of the law established by our colonial ancestors? There would not be a tittle of positive evidence against the prisoner, nothing but circumstantial evidence. An ingenious combination might be made to lead to any conclusion. Justice was all that his client asked. She appealed to liberal and high-minded men, and she rejoiced in the privilege of doing so, to accord her that justice they would demand for themselves. Mr. Deveau was not cross-examined. Evidence resumed. Dr. E. W. North sworn, cautioned by Attorney General to avoid hearsay evidence. Was the family physician of Mrs. Rowand. Went on the 6th January, at Mrs. Rowand's request, to see her at her mother's in Logan Street, found her downstairs in sitting room. She was in a nervous and excited state, had been so for a month before. He had attended her. She said nothing to witness of slave Maria. Found Maria in a chamber, upstairs, about 1:00 p.m. She was dead. She appeared to have been dead about an hour and a half. His attention was attracted to a piece of pine wood on a trunk or table in the room. It had a large knot on one end. Had it been used on Maria, it must have caused considerable contusion. Other pieces of wood were in a box, and much smaller ones. The corpse was lying one side in chamber. It was not laid out. Presumed she died there. The marks on the body were, to witness's view, very slight, some scratches about the face. He purposely avoided making an examination, observed no injuries about the head, had no conversation with Mrs. Rowand about Maria, left the house. It was on the 6th January last, the day before the inquest. Knew the slave before, but had never attended her. Cross-examined. Mrs. Rowand was in feeble health and nervous. The slave Maria was weak and emaciated in appearance. Sudden death of such a person, in such a state, from apoplexy or action of nervous system, not unlikely. Her sudden death would not imply violence. Had prescribed asafoetida for Mrs. Rowand in a former visit. It is an appropriate remedy for nervous disorders. Mrs. Rowand was not of bodily strength to handle the pine knot so as to give a severe blow. Mrs. Rowand has 5 or 6 children, the elder of them large enough to have carried pieces of the wood about the room. There must have been a severe contusion, and much extravasation of blood, to infer death from violence in this case. Apoplexy is frequently attended with extravasation of blood. There were 2 Marias in the family. In reply. Mrs. Rowand could have raised the pine knot, but could not have struck a blow with it. Such a piece of wood could have produced death, but it would have left its mark. Saw the fellow Richard, he was quite capable of giving such a blow. Dr. Peter Porcher was called in by the coroner's jury to examine Maria's body. Found it in the wash kitchen. It was the corpse of one feeble and emaciated, partly prepared for burial. Had the clothes removed. The body was lacerated with stripes, abrasions about face and knuckles, skin knocked off, passed his hand over the head. No bone broken. On request, opened her thorax and examined the viscera. Found them healthy, heart unusually so for one her age. No particular odor. Some undigested food. No inflammation. Removed the scalp and found considerable extravasation between scalp and skull. Scalp bloodshot. Just under the scalp found the effects of a single blow, just over the right ear. After removing the scalp, lifted the bone. No rupture of any blood vessel. Some softening of the brain in the upper hemisphere. There was considerable extravasation under the scalp, the result of a succession of blows on the top of the head. This extravasation was general, but that over the ear was a single spot. The butt end of a cowhide would have sufficed for this purpose. An ordinary stick, a heavy one, would have done it. A succession of blows on the head in a feeble woman would lead to death, when in a stronger one it would not. Saw no other appearance about her person to account for her death except those blows. Cross-examined. To a patient in this woman's condition, the blows would probably cause death. They were not such as were calculated to kill an ordinary person. Witness saw the body 24 hours after her death. It was winter and bitter cold, no disorganization, and the examination was therefore to be relied on. The blow behind the ear might have resulted from a fall, but not the blow on the top of the head, unless she fell head foremost, came to the conclusion of a succession of blows from the extent of the extravasation. A single blow would have shown a distinct spot, with a gradual spreading or diffusion. One large blow could not account for it, as the head was spherical, no blood on the brain. The softening of the brain did not amount to much, in an ordinary dissection would have passed it over. Anger sometimes produces apoplexy, which results in death. Blood between the scalp and the bone of the skull. It was evidently a fresh extravasation. 24 hours would scarcely have made any change. Knew nothing of this negro before. Even after examination, the cause of death is sometimes inscrutable. Not usual, however. In reply, does not attribute the softening of the brain to the blows. It was slight, and might have been the result of age. It was some evidence of impairment of vital powers by advancing age. Dr. A. P. Hayne, at request of the coroner, acted with Dr. Porcher, was shown into an outhouse, saw on the back of the corpse evidences of contusion, arms swollen and enlarged, laceration of body, contusions on neck and head, between scalp and skull extravasation of blood, on the top of head and behind the right ear, a burn on the hand. The brain presented healthy appearance, opened the body, and no evidences of disease in the chest or viscera. Attributed the extravasation of blood to external injury from blows from a large and broad and blunt instrument. Attributes the death to those blows, supposes they were adequate to cause death, as she was old, weak, and emaciated. Cross-examined. Would not have caused death in a young and robust person. The evidence for the prosecution here closed, and no witnesses were called for the defense. The jury were then successively addressed, ably and eloquently, by J. L. Pettigrew and James S. Rhett, Esquires, on behalf of the prisoner, and H. Bailey, Esquire, on behalf of the state, and by B. F. Hunt, Esquire, in reply. Of those speeches, and also of the judge's charge, we have taken full notes, but have neither time nor space to insert them here. His Honor Judge O'Neill then charged the jury eloquently and ably on the facts, vindicating the existing law, making death the penalty for the murder of a slave, but on the law intimated to the jury that he held the Act of 1740 so far still in force as to admit of the prisoner's exculpation by her own oath, unless clearly disproved by the oaths of 2 witnesses, that they were, therefore, in his opinion, bound to acquit, although he left it to them, wholly, to say whether the prisoner was guilty of murder, killing in sudden heat and passion, or not guilty. The jury then retired, and in about 20 or 30 minutes returned with a verdict of not guilty. There are some points which appear in this statement of the trial, especially in the plea for the defense. Particular attention is called to the following passage. Fortunately, said the lawyer, the jury were of the country, acquainted with our policy and practice, composed of men too honorable to be led astray by the noise and clamor out of doors. All was now as it should be. At least, a court of justice had assembled to which his client had fled for refuge and safety. Its threshold was sacred. No profane clamors entered there, but legal investigation was had of facts. From this it plainly appears that the case was a notorious one, so notorious and atrocious as to break through all the apathy which slave-holding institutions tend to produce, and to surround the courthouse with noise and clamor. From another intimation of the same speech, it would appear that there was abundant testimony of slaves to the direct fact, testimony which left no kind of doubt on the popular mind. Why else does he thus earnestly warn the jury? He warned the jury that they were to listen to no evidence but that of free white persons, given on oath in open court, they were to imagine none that came not from them. It was for this that they were selected, their intelligence putting them beyond the influence of unfounded accusations, unsustained by legal proof, of legends of aggravated cruelty, founded on the evidence of negroes, and arising from weak and wicked falsehoods. See also this remarkable admission. Truth had been distorted in this case, and murder manufactured out of what was nothing more than ordinary domestic discipline. If the reader refers to the testimony, he will find it testified that the woman appeared to be about 60 years old, that she was much emaciated, that there had been a succession of blows on the top of her head, and one violent one over the ear, and that, in the opinion of a surgeon, these blows were sufficient to cause death. Yet the lawyer for the defense coolly remarks that murder had been manufactured out of what was ordinary domestic discipline. Are we to understand that beating feeble old women on the head in this manner is a specimen of ordinary domestic discipline in Charleston? What would have been said if any anti-slavery newspaper at the North had made such an assertion as this? Yet the Charleston Courier reports this statement without comment or denial. But let us hear the lady's lawyer go still further in vindication of this ordinary domestic discipline. Chastisement must be inflicted until subordination is produced, and the extent of the punishment is not to be judged by one's neighbors but by himself. The event in this case has been unfortunate and sad. The lawyer admits that the result of thumping a feeble old woman on the head has in this case been unfortunate and sad. The old thing had not strength to bear it, and had no greater regard for the convenience of the family and the reputation of the institution than to die, and so get the family and the community generally into trouble. It will appear from this that in most cases where old women are thumped on the head, they have stronger constitutions or more consideration. Again he says, when punishment is due to the slave, the master must not be held to strict account for going an inch beyond the mark. And finally, the most astounding of all comes this. He bade the jury remember the words of him who spake as never man spoke. Let him that hath never sinned throw the first stone. They, as masters, might regret excesses to which they themselves might have carried punishment. What sort of insinuation is this? Did he mean to say that almost all the jurymen had probably done things of the same sort, and therefore could have nothing to say in this case? And did no member of the jury get up and resent such a charge? From all that appears, the jury acquiesced in it as quite a matter of course, and the Charleston Courier quotes it without comment, in the record of a trial which it says will show to the world how the law extends the aegis of her protection alike over the white man and the humblest slave. Lastly, notice the decision of the judge, which has become law in South Carolina. What point does it establish? That the simple oath of the master, in face of all circumstantial evidence to the contrary, may clear him when the murder of a slave is in question. And this trial is paraded as a triumphant specimen of legal impartiality and equity? If the light that is in thee be darkness, how great is that darkness? End of Part 2, Chapter 7. The Execution of Justice.
Part 2, Chapter 8 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Chapter 8, The Good Old Times. A Refinement in Humanity of a Doubtful Policy. B.F. Hunt. The author takes no pleasure in presenting to her readers the shocking details of the following case, but it seems necessary to exhibit what were the actual workings of the ancient law of South Carolina, which has been characterized as one conformed to the policy and approved by the wisdom of the fathers of that state, and the reform of which has been called a refinement in humanity of doubtful policy. It is well also to add the charge of Judge Wilds, partly for its intrinsic literary merit, and the nobleness of its sentiments, but principally because it exhibits such a contrast as could scarcely be found elsewhere between the judge's high and indignant sense of justice, and the shameful impotence and imbecility of the laws under which he acted. The case was brought to the author's knowledge by a letter from a gentleman of Pennsylvania, from which the following is an extract. Quote, "Sometime between the years 1807 and 1810, there was lying in the harbor of Charleston a ship commanded by a man named Slater. His crew were slaves. One of them committed some offense not specified in the narrative. The captain ordered him to be bound and laid upon the deck, and there in the harbor of Charleston in the broad daylight compelled another slave sailor to chop off his head. The affair was public, notorious. A prosecution was commenced against him. The offense was proved beyond all doubt. Perhaps, indeed, it was not denied. And the judge, in a most eloquent charge or rebuke of the defendant, expressed his sincere regret that he could inflict no punishment under the laws of the state. I was studying law when the case was published in Hall's American Law Journal, Volume 1. I have not seen the book for 25 or 30 years. I may be in error as to names, etc., but while I have life in my senses, the facts of the case cannot be forgotten." End quote. The following is the charge alluded to in the above letter. It was pronounced by the Honorable Judge Wilds of South Carolina, and is copied from Hall's Law Journal, Volume 1, page 67. Quote, "John Slater, you have been convicted by a jury of your country of the wilful murder of your own slave, and I am sorry to say the short, impressive, uncontradicted testimony on which that conviction was founded leaves but too little room to doubt its propriety. The annals of human depravity might be safely challenged for a parallel to this unfeeling, bloody, and diabolical transaction. You caused your unoffending, unresisting slave to be bound hand and foot, and by a refinement in cruelty compelled his companion, perhaps the friend of his heart, to chop his head with an axe, and to cast his body, yet convulsing with the agonies of death, into the water. And this deed you dared to perpetrate in the very harbor of Charleston, within a few yards of the shore, unblushingly in the face of open day. Had your murderous arm been raised against your equals, whom the laws of self-defense and the more efficacious law of the land unite to protect, your crimes would not have been without precedent, and would have seemed less horrid. Your personal risk would at least have proved that, though a murderer, you were not a coward. But you too well knew that this unfortunate man, whom chance had subjected to your caprice, had not, like yourself, chartered to him by the laws of the land the sacred rights of nature, and that a stern but necessary policy had disarmed him of the rights of self-defense. Too well you knew that to you alone he could look for protection, and that your arm alone could shield him from oppression or avenge his wrongs. Yet that arm you cruelly stretched out for his destruction. The counsel who generously volunteered his services in your behalf, shocked at the enormity of your offense, endeavored to find a refuge, as well for his own feelings as for those of all who heard your trial, in a derangement of your intellect. Several witnesses were examined to establish this fact, but the result of their testimony, it is apprehended, was as little satisfactory to his mind as to those of the jury to whom it was addressed. I sincerely wish this defense had proved successful, not from any desire to save you from the punishment which awaits you, and which you so richly merit, but from the desire of saving my country from the foul reproach of having in its bosom so great a monster. From the peculiar situation of this country, our fathers felt themselves justified in subjecting to a very slight punishment him who murders a slave. Whether the present state of society require a continuation of this policy, so opposite to the apparent rights of humanity, it remains for a subsequent legislature to decide. Their attention would, ere this, have been directed to this subject, but for the honor of human nature such hardened sinners as yourself are rarely found, to disturb the repose of society. The grand jury of this district, deeply impressed with your daring outrage against the laws both of God and man, have made a very strong expression of their feelings on the subject to the Legislature, and from the wisdom and justice of that body the friends of humanity may confidently hope soon to see this blackest in the catalogue of human crimes pursued by appropriate punishment. In proceeding to pass the sentence which the law provides for your offense, I confess I have never felt more forcibly the want of power to make respected the laws of my country, whose minister I am. You have already violated the majesty of those laws. You have profanely pleaded the law under which you stand convicted as a justification of your crime. You have held that law in one hand and brandished your bloody axe in the other, impiously contending that the one gave a license to the unrestrained use of the other. But though you will go off unhurt in person by the present sentence, expect not to escape with impunity. Your bloody deed has set a mark upon you which I fear the good actions of your future life will not efface. You will be held in abhorrence by an impartial world, and shunned as a monster by every honest man. Your unoffending posterity will be visited, for your iniquity, by the stigma of deriving their origin from an unfeeling murderer. Your days, which will be but few, will be spent in wretchedness, and if your conscience be not steeled against every virtuous emotion, if you be not entirely abandoned to hardness of heart, the mangled, mutilated corpse of your murdered slave will ever be present in your imagination, obtrude itself into all your amusements, and haunt you in the hours of silence and repose. But, should you disregard the reproaches of an offended world, should you hear with callous insensibility the gnawings of a guilty conscience, yet remember, I charge you, remember that an awful period is fast approaching, and with you is close at hand, when you must appear before a tribunal whose want of power can afford you no prospect of impunity, when you must raise your bloody hands at the bar of an impartial, omniscient judge. Remember, I pray you, remember whilst yet you have time that God is just, and that his vengeance will not sleep forever." The penalty that followed this solemn denunciation was a fine of £700 current money, or, in default of payment, imprisonment for 7 years. And yet it seems that there have not been wanting those who consider the reform of this law a refinement and humanity of doubtful policy. To this sentiment so high an authority as that of Chancellor Harper is quoted, as the reader will see by referring to the speech of Mr. Hunt in the last chapter. And as is very common in such cases, the old law is vindicated as being on the whole a surer protection to the life of the slave than the new one. From the results of the last 2 trials there would seem to be a fair show of plausibility in the argument, for under the old law it seems that Slater had at least to pay £700, while under the new Eliza Rowland comes off with only the penalty of a most sifting scrutiny. Thus it appears the penalty of the law goes with the murderer of the slave. How is it executed in the cases which concern the life of the master? Look at this short notice of a recent trial of this kind, which is given in the Alexandria, Virginia Gazette of October 23, 1852, has an extract from the Charleston, Virginia Free Press. Quote, "Trial of Negro Henry. The trial of this slave for an attack with intent to kill on the person of Mr. Harrison Anderson was commenced on Monday and concluded on Tuesday evening. His Honor Braxton Davenport, Esquire, Chief Justice of the county, with 4 associate gentlemen justices, composed the court. The Commonwealth was represented by its attorney, Charles B. Harding, Esquire, and the accused ably and eloquently defended by William C. Worthington and John A. Thompson, Esquires. The evidence of the prisoner's guilt was conclusive. A majority of the court thought that he ought to suffer the extreme penalty of the law, but as this required a unanimous agreement, he was sentenced to receive 500 lashes, not more than 39 at one time. The physician of the jail was instructed to see that they should not be administered too frequently, and only when, in his opinion, he could bear them. In another paper we are told that the Free Press says, "A majority of this court thought that he ought to suffer the extreme penalty of the law, but as this required a unanimous agreement, he was sentenced to receive 500 lashes, not more than 39 at any one time. The physician of the jail was instructed to see that they should not be administered too frequently, and only when, in his opinion, he could bear them. This may seem to be a harsh and inhumane punishment, but when we take into consideration that it is in accordance with the law of the land, and the further fact that the insubordination among the slaves of that state has become truly alarming, we cannot question the righteousness of the judgment." Will anybody say that the master's life is in more danger from the slave than the slave's from the master? That this disproportionate retribution is meted out? Those who countenance such legislation will do well to ponder the solemn words of an ancient book, inspired by one who is no respecter of persons: "If I have refused justice to my manservant or maidservant, when they had a cause with me, what shall I do when God riseth up? And when he visiteth, what shall I answer him? Did not he that made me in the womb make him? Did not the same God fashion us in the womb?" Job 31:13-15. End of Part 2, Chapter 8. The Good Old Times. Recording by Philip Gould.
Part 2, Chapter 9 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Colleen McMahon. Chapter 9. Moderate Correction and Accidental Death. State v. Castleman. The author remarks that the record of the following trial was read by her a little time before writing the account of the death of Uncle Tom. The shocking particulars haunted her mind, and were in her thoughts when the following sentence was written: "What man has nerve to do, man has not nerve to hear. What brother man and brother Christian must suffer cannot be told us, even in our secret chamber it so harrows up the soul. And yet, O my country, these things are done under the shadow of thy laws. O Christ, thy church sees them almost in silence." It is given precisely as prepared by Dr. G. Bailey, the very liberal and fair-minded editor of the National Era. From the National Era, Washington, November 6, 1851. Homicide case in Clark County, Virginia. Some time since, the newspapers of Virginia contained an account of a horrible tragedy enacted in Clark County of that state. A slave of Colonel James Castleman, it was stated, had been chained by the neck and whipped to death by his master on the charge of stealing. The whole neighborhood in which the transaction occurred was incensed. The Virginia papers abounded in denunciations of the cruel act, and the people of the North were called upon to bear witness to the justice which would surely be meted out in a slave state to the master of a slave. We did not publish the account. The case was horrible. It was, we were confident, exceptional. It should not be taken as evidence of the general treatment of slaves. We chose to delay any notice of it till the courts should pronounce their judgment, and we could announce at once the crime and its punishment, so that the state might stand acquitted of the foul deed. Those who were so shocked at the transaction will be surprised and mortified to hear that the actors in it have been tried and acquitted, and when they read the following account of the trial and verdict, published at the instance of the friends of the accused, their mortification will deepen into bitter indignation. From The Spirit of Jefferson. Colonel James Castleman. The following statement, understood to have been drawn up by counsel since the trial, has been placed by the friends of this gentleman in our hands for publication. At the Circuit Superior Court of Clark County, commencing on the 13th of October, Judge Samuels presiding, James Castleman and his son Stephen D. Castleman were indicted jointly for the murder of Negro Lewis, property of the latter. By advice of their counsel, the parties elected to be tried separately, and the attorney for the Commonwealth directed that James Castleman should be tried first. It was proved on this trial that for many months previous to the occurrence the money drawer of the tavern kept by Stephen D. Castleman, and the liquors kept in large quantities in his cellar, had been pillaged from time to time until the thefts had attained to a considerable amount. Suspicion had, from various causes, been directed to Lewis and another Negro named Reuben, a blacksmith, the property of James Castleman, but by the aid of two of the house servants they had eluded the most vigilant watch. On the 20th of August last, in the afternoon, S. D. Castleman accidentally discovered a clue, by means of which, and through one of the house servants implicated, he was enabled to fully detect the depredators. and to ascertain the manner in which the theft had been committed. He immediately sent for his father, living near him, and after communicating what he had discovered, it was determined that the offenders should be punished at once, and before they should know of the discovery that had been made. Lewis was punished first, and in a manner as was fully shown to preclude all risk of injury to his person, by stripes with a broad leathern strap. He was punished severely, but to an extent by no means disproportionate to his offence, nor was it pretended in any quarter that this punishment implicated either his life or health. He confessed the offence, and admitted that it had been effected by false keys, furnished by the blacksmith Reuben. The latter servant was punished immediately afterwards. It was believed that he was the principal offender, and he was found to be more obdurate and contumacious than Lewis had been in reference to the offence. Thus it was proved, both by the prosecution and the defence, that he was punished with greater severity than his accomplice. It resulted in a like confession on his part, and he produced the false key, one fashioned by himself, by which the theft had been effected. It was further shown on the trial that Lewis was whipped in the upper room of a warehouse, connected with Stephen Castleman's store, and near the public road where he was at work at the time; that after he had been flogged, to secure his person whilst they went after Reuben, he was confined by a chain around his neck, which was attached to a joist above his head. The length of this chain, the breadth and thickness of the joist, its height from the floor, and the circlet of chain on the neck, were accurately measured, and it was thus shown that the chain unoccupied by the circlet and the joist was 1.5 feet longer than the space between the shoulders of the man and the joist above, or to that extent the chain hung loose above him; that the circlet, which was fastened so as to prevent its contraction, rested on the shoulders and breast, the chain being sufficiently drawn only to prevent being slipped over his head; and that there was no other place in the room to which he could be fastened, except to one of the joists above. His hands were tied in front. A white man who had been at work with Lewis during the day was left with him by the Messrs. Castleman, the better to ensure his detention, whilst they were absent after Reuben. It was proved by this man, who was a witness for the prosecution, that Lewis asked for a box to stand on, or for something that he could jump off from; that after the Castlemans had left him he expressed a fear that when they came back he would be whipped again, and said, if he had a knife and could get one hand loose, he would cut his throat. The witness stated that the negro stood firm on his feet, that he could turn freely in whatever direction he wished, and that he made no complaint of the mode of his confinement. This man stated that he remained with Lewis about half an hour, and then left there to go home. After punishing Reuben, the Castlemans returned to the warehouse, bringing him with them, their object being to confront the two men, in the hope that by further examination of them jointly all their accomplices might be detected. They were not absent more than half an hour. When they entered the room above, Lewis was found hanging by the neck, his feet thrown behind him, his knees a few inches from the floor, and his head thrown forward. The body warm and supple or relaxed, but life was extinct. It was proved by the surgeons who made a post-mortem examination before the coroner's inquest that the death was caused by strangulation by hanging, and other eminent surgeons were examined to show, from the appearance of the brain and its blood vessels after death, as exhibited at the post-mortem examination, that the subject could not have fainted before strangulation. After the evidence was finished on both sides, the jury from their box and of their own motion, without a word from counsel on either side, informed the court that they had agreed upon their verdict. The counsel assented to its being thus received, and a verdict of "not guilty" was immediately rendered. The attorney for the Commonwealth then informed the court that all the evidence for the prosecution had been laid before the jury, and as no new evidence could be offered on the trial of Stephen D. Castleman, he submitted to the court the propriety of entering a nolle prosequi. The judge replied that the case had been fully and fairly laid before the jury upon the evidence, that the court was not only satisfied with the verdict, but if any other had been rendered it must have been set aside, and that if no further evidence was to be adduced on the trial of Stephen, the attorney for the Commonwealth would exercise a proper discretion in entering a nolle prosequi as to him, and the court would approve its being done. A nolle prosequi was entered accordingly, and both gentlemen discharged. It may be added that 2 days were consumed in exhibiting the evidence, and that the trial was by a jury of Clark County. Both the parties had been on bail from the time of their arrest, and continued on bail whilst the trial was depending. Let us admit that the evidence does not prove the legal crime of homicide. What candid man can doubt, after reading this ex parte version of it, that the slave died in consequence of the punishment inflicted upon him? In criminal prosecutions, the Federal Constitution guarantees to the accused the right to a public trial by an impartial jury, the right to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witness in his favor, and to have the assistance of counsel, guarantees necessary to secure innocence against hasty or vindictive judgment, absolutely necessary to prevent injustice. Grant that they were not intended for slaves, every master of a slave must feel that they are still morally binding upon him. He is the sole judge. He alone determines the offense, the proof requisite to establish it, and the amount of the punishment. The slave then has a peculiar claim upon him for justice. When charged with a crime, common humanity requires he should be informed of it, that he should be confronted with the witnesses against him, that he should be permitted to show evidence in favor of his innocence. But how was poor Lewis treated? The son of Castleman said he had discovered who stole the money, and it was forthwith determined that the offenders should be punished at once, and before they should know of the discovery that had been made. Punished without a hearing. Punished on the testimony of a house servant, the nature of which does not appear to have been inquired into by the court. Not a word is said which authorizes the belief that any careful examination was made as it respects their guilt. Lewis and Reuben were assumed, on loose evidence, without deliberate investigation, to be guilty, and then, without allowing them to attempt to show their evidence, they were whipped until a confession of guilt was extorted by bodily pain. Is this Virginia justice? Lewis was punished with a broad leathern strap. He was punished severely. This we do not need to be told. A broad leathern strap is well adapted to severity of punishment. Nor was it pretended, the account says, in any quarter that this punishment implicated either his life or his health. This is false. It was expressly stated in the newspaper accounts at the time, and such was the general impression in the neighborhood, that the punishment did very severely implicate his life. But more of this anon. Lewis was left. A chain was fastened around his neck so as not to choke him, and secured to the joist above, leaving a slack of about 1.5 feet. Remaining in an upright position, he was secure against strangulation, but he could neither sit nor kneel, and should he faint, he would be choked to death. The account says that they fastened him thus for the purpose of securing him. If this had been the sole object, it could have been accomplished by safer and less cruel methods, as every reader must know. This mode of securing him was intended probably to intimidate him, and at the same time afforded some gratification to the vindictive feeling which controlled the actors in this foul transaction. The man whom they left to watch Lewis said that after remaining there about half an hour he went home, and Lewis was then alive. The Castlemans say that after punishing Reuben they returned, having been absent not more than half an hour, and they found him hanging by the neck, dead. We direct attention to this part of the testimony to show how loose the statements were which went to make up the evidence. Why was Lewis chained at all, and a man left to watch him? To secure him, say the Castlemans. Is it customary to chain slaves in this manner, and set a watch over them after severe punishment, to prevent their running away? If the punishment of Lewis had not been unusual, and if he had not been threatened with another infliction on their return, there would have been no necessity for chaining him. The testimony of the man left to watch represents him as desperate apparently with pain and fright. Lewis asked for a box to stand on. Why? Was he not suffering from pain and exhaustion, and did he not wish to rest himself without danger of slow strangulation? Again, he asked for something he could jump off from. After the Castlemans left, he expressed a fear when they came back that he would be whipped again, and said if he had a knife and could get one hand loose, he would cut his throat. The punishment that could drive him to such desperation must have been horrible. How long they were absent we know not, for the testimony on this point is contradictory. They found him hanging by the neck dead, his feet thrown behind him, his knees a few inches from the floor, and his head thrown forward, just the position he would naturally fall into had he sunk from exhaustion. They wish it to appear that he hung himself. Could this be proved, we need hardly say that it is not, it would relieve but slightly the dark picture of their guilt. The probability is that he sank, exhausted by suffering, fatigue, and fear. As to the testimony of surgeons, founded upon a post mortem examination of the brain and blood vessels, that the subject could not have fainted before strangulation, it is not worthy of consideration. We know something of the fallacies and fooleries of such examinations. From all we can learn, the only evidence relied on by the prosecution was that white man employed by the Castlemans. He was dependent upon them for work. Other evidence might have been obtained. Why it was not is for the prosecuting attorney to explain. To prove what we say, and to show that justice has not been done in this horrible affair, we publish the following communication from an old and highly respectable citizen of this place, and who is very far from being an abolitionist. The slaveholders whom he mentions are well known here, and would have promptly appeared in the case had the prosecution, which was aware of their readiness, summoned them. To the Editor of the Era: I see that Castleman, who lately had a trial for whipping a slave to death in Virginia, was triumphantly acquitted, as many expected. There are 3 persons in this city with whom I am acquainted who stayed at Castleman's the same night in which this awful tragedy was enacted. They heard the dreadful lashing, and the heartrending screams and entreaties of the sufferer. They implored the only white man they could find on the premises, not engaged in the bloody work, to interpose, but for a long time he refused, on the ground that he was a dependent and afraid to give offence, and that moreover they had been drinking, and he was in fear for his own life should he say a word that would be displeasing to them. He did, however, venture, and returned and reported the cruel manner in which the slaves were chained and lashed, and secured in a blacksmith's vice. In the morning, when they ascertained that one of the slaves was dead, they were so shocked and indignant that they refused to eat in the house, and reproached Castleman with his cruelty. He expressed his regret that the slave had died, and especially as he had ascertained that he was innocent of the accusation for which he had suffered. The idea was that he had fainted from exhaustion, and, the chain being round his neck, he was strangled. The persons I refer to are themselves slaveholders, but their feelings were so harrowed and lacerated that they could not sleep. 2 of them are ladies, and for many nights afterwards their rest was disturbed, and their dreams made frightful by the appalling recollection. These persons would have been material witnesses, and would have willingly attended on the part of the prosecution. The knowledge they had of the case was communicated to the proper authorities, yet their attendance was not required. The only witness was that dependent who considered his own life in danger. Yours, etc., J.F. The account, as published by the friends of the accused parties, shows a case of extreme cruelty. The statements made by our correspondent prove that the truth has not been fully revealed, and that justice has been baffled. The result of the trial shows how irresponsible is the power of a master over his slave, and that whatever security the latter has is to be sought in the humanity of the former, not in the guarantees of law. Against the cruelty of an inhuman master he has really no safeguard. Our conduct in relation to this case, deferring all notice of it in our columns till a legal investigation could be had, shows that we are not disposed to be captious towards our slaveholding countrymen. In no unkind spirit have we examined this lamentable case, but we must expose the utter repugnance of the slave system to the proper administration of justice. The newspapers of Virginia generally publish the account from the spirit of Jefferson without comment. They are evidently not satisfied that justice was done. They, doubtless, will deny that the accused were guilty of homicide legally, but they will not deny that they were guilty of an atrocity which should brand them forever in a Christian country. End of Part 2, Chapter 9. Recording by Colleen McMahon.
Part 2, Chapter 10 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information, or to volunteer, please visit LibriVox.org. Recording by Kathleen. Chapter 10. Principles Established. State versus Legree. A case not in the books. From a review of all the legal cases which have hitherto been presented, and of the principles established in the judicial decisions upon them, the following facts must be apparent to the reader. First, that masters do, now and then, kill slaves by the torture. Second, that the fact of so killing a slave is not of itself held presumption of murder in slave jurisprudence. Third, that the slave in the act of resistance to his master may always be killed. From these things it will be seen to follow, that, if the facts of the death of Tom had been fully proved by 2 white witnesses, in open court, Legree could not have been held by any consistent interpreter of slave law to be a murderer, for Tom was in the act of resistance to the will of his master. His master had laid a command on him, in the presence of other slaves. Tom had deliberately refused to obey the command. The master commenced chastisement to reduce him to obedience, and it is evident, at the first glance, to everyone, that, if the law does not sustain him in enforcing obedience in such a case, there is an end of the whole slave power. No Southern court would dare to decide that Legree did wrong to continue the punishment, as long as Tom continued the insubordination. Legree stood by him every moment of the time, pressing him to yield, and offering to let him go as soon as he did yield. Tom's resistance was insurrection. It was an example which could not be allowed, for a moment, on any Southern plantation. By the express words of the Constitution of Georgia, and by the understanding and usage of all slave law, the power of life and death is always left in the hands of the master. In exigences like this is not a case like that of Souther versus the Commonwealth. The victim of Souther was not in a state of resistance or insurrection. The punishment, in this case, was a simple vengeance for a past offense, and not an attempt to reduce him to subordination. There is no principle of slave jurisprudence by which a man could be pronounced a murderer, for acting as Legree did, in his circumstances. Everybody must see that such an admission would strike at the foundations of the slave system. To be sure, Tom was in a state of insurrection for conscience' sake, but the law does not, and cannot, contemplate that the Negro shall have a conscience independent of his master's. To allow that, the Negro must refuse to obey his master whenever he thinks that obedience would be wrong, would be to produce universal anarchy. If Tom had been allowed to disobey his master in this case, for conscience' sake, the next day Sambo would have had a case of conscience, and Quimbo the next. Several of them might very justly have thought that it was a sin to work as they did. The mulatto woman would have remembered that the command of God forbade her to take another husband. Mothers might have considered that it was more their duty to stay at home and take care of their children when they were young and feeble, than to work for Mr. Legree in the cotton field. There would be no end to the havoc made upon cotton-growing operations. Were the Negro allowed the right of maintaining his own conscience on moral subjects, if the slave system is a right system, and ought to be maintained, Mr. Legree ought not to be blamed for his conduct in this case, for he did only what was absolutely essential to maintain the system, and Tom died in fanatical and foolhardy resistance to the powers that be, which are ordained of God. He followed a sentimental impulse of his desperately depraved heart, and neglected those solid teachings of the written word, which, as recently elucidated, have proved so refreshing to eminent political men. End of Part 2, Chapter 10. Principles Established. State versus Legree. A case not in the books. Part 2, Chapter 11 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Kathleen. Chapter 11. The Triumph of Justice over Law. Having been obliged to record so many trials in which justice has been turned away backward by the hand of law, and equity and common humanity have been kept out by the bolt and bar of logic, it is a relief to the mind to find one recent trial recorded, in North Carolina, in which the nobler feelings of the human heart have burst over formalized limits, and where the prosecution appears to have been conducted by men who were not ashamed of possessing in their bosoms that very dangerous and most illogical agitator, a human heart. It is true that, in giving this trial, very sorrowful, but inevitable, inferences will force themselves upon the mind, as to that state of public feeling which allowed such outrages to be perpetrated in open daylight, in the capital of North Carolina, upon a hapless woman. It would seem that the public were too truly instructed in the awful doctrine pronounced by Judge Ruffin, that the power of the master must be absolute, to think of interfering while the poor creature was dragged, barefoot and bleeding, at a horse's neck, at the rate of 5 miles an hour, through the streets of Raleigh. It seems, also, that the most horrible brutalities and enormities that could be conceived of were witnessed, without any efficient interference, by a number of the citizens, among whom we see the name of the Honorable W.H. Haywood, of Raleigh. It is a comfort to find the Attorney General, in this case, speaking as a man ought to speak. Certainly there can be no occasion to which to pervert or overstate the dread workings of the slave system, or to leave out the few comforting and encouraging features, however small the encouragement of them may be. The case is now presented, as narrated from the published reports, by Dr. Bailey, editor of the National Era, a man whose candor and fairness need no endorsing, as every line that he writes speaks for itself. The reader may at first be surprised to find slave testimony in the court, till he recollects that it is a slave that is on trial, the testimony of slaves being only null when it concerns whites. An interesting trial. We find in one of the Raleigh, North Carolina, papers, of June 5, 1851, a report of an interesting trial at the spring term of the Superior Court. Mima, a slave, was indicted for the murder of her master, William Smith, of Johnston County, on the night of the 29th of November, 1850. The evidence for the prosecution was Sidney, a slave boy, 12 years old, who testified that, in the night, he and a slave girl, named Jane, were roused from sleep by the call of their master, Smith, who had returned home. They went out and found Mima tied to his horse's neck, with 2 ropes, one round her neck, the other round her hands. Deceased carried her into the house, jerking the rope fastened to her neck, and tied her to a post. He called for something to eat, threw her a piece of bread, and, after he had done, beat her on her naked back with a large piece of light wood, giving her many hard blows. In a short time, deceased went out of the house for a special purpose, witness accompanying him with a torchlight, and hearing him say that he intended to use the prisoner up. The light was extinguished, and he re-entered the house for the purpose of lighting it. Jane was there, but the prisoner had been untied, and was not there. While lighting his torch, he heard blows outside, and heard the deceased cry out, 2 or 3 times, "Oh, Leah! Oh, Leah!" Witness and Jane went out, saw the deceased bloody and struggling, were frightened, ran back, and shut themselves up. Leah, it seems, was mother of the prisoner, and had run off 2 years, on account of cruel treatment by the deceased. Smith was speechless and unconscious till he died, the following morning, of the wounds inflicted on him. It was proved on the trial that Carroll, a white man, living about a mile from the house of the deceased, and whose wife was said to be the illegitimate daughter of Smith, had in his possession, the morning of the murder, the receipt given the deceased by Sheriff High, the day before, for jail fees, and a note for $35, due deceased from one Riley Price, which Carroll collected a short time thereafter, also the chest keys of the deceased, and no proof was offered to show how Carroll came into possession of these articles. The following portion of the testimony discloses facts so horrible, and so disgraceful to the people who tolerated, in broad daylight, conduct which would have shamed the devil, that we copy it just as we find it in the Raleigh paper. The scene, remember, is the city of Raleigh. The defense was then opened. James Harris, C.W.D. Hutchings, and Hon. W.H. Haywood, of Raleigh, John Cooper, of Wake, Joseph Hayne, and others, of Johnston, were examined for the prisoner. The substance of their testimony was as follows. On the forenoon of Friday, 29th of November last, deceased took prisoner from Raleigh jail, tied her round the neck and wrist. Ropes were then latched to the horse's neck. He cursed the prisoner several times, got on his horse, and started off. When he got opposite the telegraph office, on Fayetteville Street, he pulled her shoes and stockings off, cursed her again, went off in a swift trot, the prisoner running after him, doing apparently all she could to keep up, passed round by Peck's store. Prisoner seemed very humble and submissive, took down the street east of the Capitol, going at the rate of 5 miles an hour, continued this gait until he passed O'Rourke's Corner, about half or 3/4 of a mile from the Capitol, that he reached Cooper's, one of the witnesses, 13 miles from Raleigh, about 4 o'clock p.m., that it was raining very hard. Deceased got off his horse, turned it loose with prisoner tied to its neck. Witness went to take deceased horse to stable, heard great lamentations at the house, hurried back, saw his little daughter running through the rain from the house, much frightened, got there. Deceased was gouging prisoner in the eyes, and she making outcries, made him stop, became vexed, and insisted upon leaving. Did leave in a short time, in the rain, sun about an hour high. When he left, prisoner was tied as she was before. Her arms and fingers were very much swollen. The rope around her wrist was small, and had sunk deep into the flesh, almost covered with it. That around the neck was large, and tied in a slip knot. Deceased would jerk it every now and then. When jerked, it would choke prisoner. She was barefoot and bleeding. Deceased was met some time after dark, in about 6 miles of home, being 24 or 25 from Raleigh. Why did they not strike the monster to the earth, and punish him for his infernal brutality? The Attorney General conducted the prosecution with evident loathing. The defense argued, first, that the evidence was insufficient to fasten the crime upon the prisoner. Secondly, that, should the jury be satisfied beyond a rational doubt that the prisoner committed the act charged, it would yet be only manslaughter. A single blow between equals would mitigate a killing instanter from murder to manslaughter. It could not, in law, be anything more, if done under the furor brevis of passion. But the rule was different as between master and slave. It was necessary that this should be, to preserve the subordination of the slave. The prisoner's counsel then examined the authorities at length, and contended that the prisoner's case came within the rule laid down in the State v. Will 1 Devereux and Battle 121. The rule there given by Judge Gaston is this: if a slave, in defense of his life, and under circumstances strongly calculated to excite his passions of terror and resentment, kill his overseer or master, the homicide is, by such circumstances, mitigated to manslaughter. The cruelties of the deceased to the prisoner were grievous and long continued. They would have shocked a barbarian. The savage loves and thirsts for blood, but the acts of civilized life have not afforded him such refinement of torture as was here exhibited. The Attorney General, after discussing the law, appealed to the jury not to suffer the prejudice which the counsel for the defense had attempted to create against the deceased, whose conduct, he admitted, was disgraceful to human nature, to influence their judgments in deciding whether the act of the prisoner was criminal or not, and what degree of criminality attached to it. He desired the prisoner to have a fair and impartial trial. He wished her to receive the benefit of every rational doubt. It was her right, however humble her condition. He hoped he had not that heart, as he certainly had not the right by virtue of his office, to ask in her case for anything more than he would ask from the highest and proudest of the land on trial, that the jury should decide according to the evidence, and vindicate the violated law. These were honorable sentiments. After an able charge by Judge Ellis, the jury retired, and, after having remained out several hours, returned with a verdict of not guilty. Of course, we see not how they could hesitate to come to this verdict at once. The correspondent who furnishes the Register with a report of the case says, "It excited an intense interest in the community in which it occurred, and, although it develops a series of cruelties shocking to human nature, the result of the trial, nevertheless, vindicates the benignity and justice of our laws towards that class of our population whose condition Northern fanaticism has so carefully and grossly misrepresented, for their own purposes of selfishness, agitation, and crime. We have no disposition to misrepresent the condition of the slaves, or to disparage the laws of North Carolina, but we ask, with a sincere desire to know the truth, do the laws of North Carolina allow a master to practice such horrible cruelties upon his slaves as Smith was guilty of? And would the public sentiment of the city of Raleigh permit a repetition of such enormities as were perpetrated in its streets, in the light of day, by that miscreant? In conclusion, as the accounts of these various trials contain so many shocking incidents and particulars, the author desires to enter a caution against certain mistaken uses which may be made of them by well-intending persons. The crimes themselves, which form the foundation of the trials, are not to be considered and spoken of as specimens of the common working of the slave system. They are, it is true, the logical and legitimate fruits of a system which makes every individual owner an irresponsible despot. But the actual number of them, compared with the whole number of masters, we take pleasure in saying, is small. It is an injury to the cause of freedom to ground the argument against slavery upon the frequency with which such scenes as these occur. It misleads the popular mind as to the real issue of the subject. To hear how many men talk, one would think that they suppose that unless negroes actually were whipped or burned alive at the rate of 2 or 3 dozen a week, there was no harm in slavery. They seem to see nothing in the system but its gross bodily abuses. If these are absent, they think there is no harm in it. They do not consider that the 12 hours' torture of some poor victim, bleeding away his life, drop by drop, under the hands of a Souther, is only a symbol of that more atrocious process by which the divine, immortal soul is mangled, burned, lacerated, thrown down, stamped upon, and suffocated by the fiend-like force of the tyrant slavery. And as, when the torturing work was done, and the poor soul flew up to the judgment seat, to stand there in awful witness, there was not a vestige of humanity left in that dishonored body. nor anything by which it could be said, "See, this was a man." So, when slavery has finished her legitimate work upon the soul, and trodden out every spark of manliness, and honor, and self-respect, and natural affection, and conscience, and religious sentiment, then there is nothing left in the soul by which to say, "This was a man," and it becomes necessary for judges to construct grave legal arguments to prove that the slave is a human being. Such extreme cases of bodily abuse from the despotic power of slavery are comparatively rare. Perhaps they may be paralleled by cases brought to light in the criminal jurisprudence of other countries. They might, perhaps, have happened anywhere. At any rate, we will concede that they might. But where under the sun did such trials of such cases ever take place, in any nation professing to be free and Christian? The reader of English history will perhaps recur to the trials under Judge Jeffreys as a parallel. A moment's reflection will convince him that there is no parallel between the cases. The decisions of Jeffreys were the decisions of a monster, who violently wrested law from its legitimate course, to gratify his own fiendish nature. The decisions of American slave law have been, for the most part, the decisions of honorable and humane men, who have wrested from their natural course the most humane feelings, to fulfill the mandates of a cruel law. In the case of Jeffreys, the sacred forms of the administration of justice were violated. In the case of the American decisions, every form has been maintained. Revolting to humanity as these decisions appear, they are strictly logical and legal. Therefore, again, we say, where, ever, in any nation professing to be civilized and Christian, did such trials of such cases take place? When were ever such legal arguments made? When ever such legal principles judiciously affirmed? Was ever such a trial held in England as that in Virginia, of Souther versus the Commonwealth? Was it ever necessary in England for a judge to declare on the bench, contrary to the opinion of a lower court, that the death of an apprentice, by 12 hours' torture from his master, did amount to murder in the first degree? Was such a decision, if given, accompanied by the affirmation of the principle, that any amount of torture inflicted by the master, short of the point of death, was not indictable? Not being read in English law, the writer cannot say, but there is strong impression from within that such a decision as this would have shaken the whole island of Great Britain, and that such a case as Souther versus the Commonwealth would never have been forgotten under the sun. Yet it is probable that very few persons in the United States ever heard of the case, or ever would have heard of it, had it not been quoted by the New York Courier and Inquirer as an overwhelming example of legal humanity. The horror of the whole matter is, that more than one such case should ever need to happen in a country, in order to make the whole community feel, as one man, that such power ought not to be left in the hands of a master. How many such cases do people wish to have happen? How many must happen, before they will learn that utter despotic power is not to be trusted in any hands? If one white man's son or brother had been treated in this way, under the law of apprenticeship, the whole country would have trembled, from Louisiana to Maine, till that law had been altered. They forget that the black man has also a Father. It is He that sitteth upon the circle of the heavens, who bringeth the princes to nothing, and maketh the judges of the earth as vanity. He hath said that, when he maketh inquisition for blood, he forgetteth not the cry of the humble. That blood which has fallen so despised to the earth, That blood which lawyers have quibbled over in the quiet of legal nonchalance, discussing in great ease whether it fell by murder in the first or second degree, he will one day reckon for as the blood of his own child. He is not slack concerning his promises, as some men count slackness, but is long suffering to usward. But the day of vengeance is surely coming, and the year of his redeemed is in his heart. Another court will sit upon these trials, when the Son of Man shall come in his glory. It will be not alone Souther, and such as he, that will be arraigned there, but all those in this nation, North and South, who have abetted the system, and made the laws which made Souther what he was. In that court Negro testimony will be received, if never before, and the judges and the counselors, and the chief men, and the mighty men, marshalled to that awful bar, will say to the mountains and the rocks, Fall on us and hide us from the face of him that sitteth on the throne, and from the wrath of the Lamb. The wrath of the Lamb, think of it. Think that Jesus Christ has been present, a witness, a silent witness through every such scene of torture and anguish, a silent witness in every such court, calmly hearing the evidence given in, the lawyers pleading, the bills filed, and cases appealed. And think what a heart Jesus Christ has, and with what age-long patience he has suffered. What awful depths are there in that word, long-suffering! And what must be that wrath, when, after ages of endurance, this dread accumulation of wrong and anguish comes up at last to judgment. End of Part 2, Chapter 11. The Triumph of Justice over Law. Part 2, Chapter 12, of A Key to Uncle Tom's Cabin, by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information, or to volunteer, please visit Librivox.org. Recording by Kathleen. Chapter 12. A comparison of the Roman law of slavery with the American. The writer has expressed the opinion that the American law of slavery, taken throughout, is a more severe one than that of any other civilized nation, ancient or modern, if we except, perhaps, that of the Spartans. She has not at hand the means of comparing French and Spanish slave codes, but, as it is a common remark that Roman slavery was much more severe than any that has ever existed in America, it will be well to compare the Roman with the American law. We therefore present a description of the Roman slave law, as quoted by William J. Esquire, from Blair's Inquiry into the State of Slavery among the Romans, giving such references to American authorities as will enable the reader to make his own comparison, and to draw his own inferences. 1. The slave had no protection against the avarice, rage, or lust of the master, whose authority was founded in absolute property, and the bond man was viewed less as a human being subject to arbitrary dominion, than as an inferior animal, dependent wholly on the will of his owner. See Law of South Carolina, in Stroud's Sketch of the Laws of Slavery, page 23. 2. Brevis Digest, 229. Prince's Digest, 446. Cobb's Digest, 971. Slaves shall be deemed, sold, taken, reputed, and adjudged in law to be chattels personal in the hands of their owners and possessors, and their executors, administrators, and assigns, to all intents, constructions, and purposes whatever. Louisiana Civil Code. Article 35. Stroud's Sketch. Page 22. A slave is one who is in the power of a master to whom he belongs. Judge Ruffin's decision in the case of the State versus Man, Wheeler's Law of Slavery, 246. Such obedience in the consequence only of uncontrolled authority over the body. There is nothing else which can operate to produce the effect. The power of the master must be absolute. To render the submission of the slave perfect. 2. At first, the master possessed the uncontrolled power of life and death. Judge Clark, in case of State of Mississippi vs. Jones, Wheeler, 252. At a very early period in Virginia, the power of life over slaves was given by statute. 3. He might kill, mutilate or torture his slaves, for any or no offense. He might force them to become gladiators or prostitutes. The privilege of killing is now somewhat abridged. As to mutilation and torture, see the case of Souther vs. the Commonwealth, 7 Grattan, 673, quoted in Chapter 3, above. Also State vs. Mann, in the same chapter. From Wheeler, page 244. 4. The temporary unions of male with female slaves were formed and dissolved at his command. Families and friends were separated when he pleased. See the decision of Judge Matthews in the case of Garrard vs. Lewis, Wheeler, 199. It is clear that slaves have no legal capacity to assent to any contract. With the consent of their master, they may marry, and their moral power to agree to such a contract or connection as that of marriage cannot be doubted, but whilst in a state of slavery it cannot produce any civil effect, because slaves are deprived of all civil rights. See also the chapter below on the separation of families, and the files of any Southern newspaper. Passim. 5. The laws recognize no obligation upon the owners of slaves to furnish them with food and clothing, or to take care of them in sickness. The extent to which this deficiency in the Roman law has been supplied in the American by protective acts has been exhibited above. Footnote. See also the case of State vs. Abram, 10 Alabama, 928, 7 U.S. Digest, page 449. The master or overseer, and not the slave, is the proper judge whether the slave is too sick to be able to labor. The latter cannot, therefore, resist the order of the former to go to work. End footnote. 6. Slaves could have no property but by the sufferance of their master, for whom they acquired everything, and with whom they could form no engagements which could be binding on him. The following chapter will show how far American legislation is in advance of that of the Romans, in that it makes it a penal offense on the part of the master to permit his slave to hold property, and a crime on the part of the slave to be so permitted. For the present purpose, we give an extract from the Civil Code of Louisiana, as quoted by Judge Stroud. Civil Code, Article 35, Stroud, page 22. A slave is one who is in the power of a master to whom he belongs. The master may sell him, dispose of his person, his industry, and his labor. He can do nothing, possess nothing, nor acquire anything but what must belong to his master. Wheeler's Law of Slavery, page 246, State vs. Mann. According to Judge Ruffin, a slave is one doomed in his own person, and his posterity, to live without knowledge, and without the capacity to make anything his own, and to toil that another may reap the fruits. With reference to the binding power of engagements between master and slave, the following decisions from the United States Digest are in point. 7, page 449. Gist vs. Toohey, 2 Richmond, 424. All the acquisitions of the slave in possession are the property of his master, notwithstanding the promise of his master that the slave shall have certain of them. In the same place, a slave paid money which he had earned over and above his wages, for the purchase of his children into the hands of B, and B purchased such children with the money, held that the master of such slave was entitled to recover the money of B. 7. The master might transfer his rights by either sale or gift, or might bequeath them by will. Law of South Carolina, Cobb's Digest, 971. Slaves shall be deemed, sold, taken, reputed and adjudged in law, to be chattels personal in the hands of their owners and possessors, and their executors, administrators, and assigns, to all intents, constructions, and purposes whatsoever. 8. A master selling, giving, or bequeathing a slave, sometimes made it a provision that he should never be carried abroad, or that he should be manumitted on a fixed day, or that, on the other hand, he should never be emancipated, or that he should be kept in chains for life. Williams v. Ashe. 1 Howard, United States Representative, 1.5 U.S. Digest, 792, Section 5. We hardly think that a provision that a slave should never be emancipated, or that he should be kept in chains for life, would be sustained. A provision that the slave should not be carried out of the state, or sold, and that on the happening of either event he should be free, has been sustained. The remainder of Blair's account of Roman slavery is devoted rather to the practices of masters than the state of the law itself. Surely, the writer is not called upon to exhibit in the society of enlightened, republican and Christian America in the 19th century a parallel to the atrocities committed in pagan Rome under the sceptre of the persecuting Caesars, when the amphitheatre was the favorite resort of the most refined of her citizens, as well as the great school of morals for the multitude. A few references only will show, as far as we desire to show, how much safer it is now to trust man with absolute power over his fellow than it was then. 9. While slaves turned the hand-mill they were generally chained, and had a broad wooden collar, to prevent them from eating the grain. The furca, which in later language means a gibbet, was, in older dialect, used to denote a wooden fork or collar, which was made to bear upon their shoulders, or around their necks, as a mark of disgrace, as much as an uneasy burden. The reader has already seen, in Chapter 5, that this instrument of degradation has been in use, in our own day, in certain of the slave states, under the express sanction and protection of statute laws, although the material is different, and the construction doubtless improved by modern ingenuity. 10. Fetters and chains were much used for punishment or restraint, and were, in some instances, worn by slaves during life, through the sole authority of the master. Porters at the gates of the rich were generally chained. Field laborers worked for the most part in irons posterior to the first ages of the Republic. The legislature of South Carolina specially sanctions the same practices, by accepting them in the protective enactment, which inflicts the penalty of £100, in case any person shall wilfully cut out the tongue, and so forth, of a slave, or shall inflict any other cruel punishment, other than by whipping or beating with a horsewhip, cowskin, switch, or small stick, or by putting irons on, or confining or imprisoning such slave. 11. Some persons made it their business to catch runaway slaves. That such a profession, constituted by the highest legislative authority in the nation, and rendered respectable by the commendation expressed or implied of statesmen and divines, and of newspapers political and religious, exists in our midst, especially in the free states, is a fact which is, day by day, making itself too apparent to need testimony. The matter seems, however, to be managed in a more perfectly open and business-like manner in the state of Alabama than elsewhere. Mr. J. cites the following advertisement from the Sumter County, Alabama, Whig. Negro Dogs. The undersigned having brought the entire pack of negro dogs of the Hay and Allen stock, he now proposes to catch runaway negroes. His charges will be $3 per day for hunting, and $15 for catching a runaway. He resides 3 1/2 miles north of Livingston, near the Lower Jones Bluff Road. William Gamble. November 6, 1845. 6M. The following is copied, verbatim et literatim, and with the pictorial embellishments, from the Dadeville, Alabama, Banner of November 10, 1852. The Dadeville Banner is devoted to politics, literature, education, agriculture, and so forth. Notice: the undersigned having an excellent pack of hounds, for trailing and catching runaway slaves, informs the public that his prices in future will be as follows for such services: for each day employed in hunting or trailing, $2.50; for catching each slave, $10; for going over 10 miles and catching slaves, $20. If sent for, the above prices will be exacted in cash. The subscriber resides 1.5 miles south of Dadeville, Alabama. B. Black. Dadeville, September 1, 1852. 1 tf. 12. The runaway, when taken, was severely punished by authority of the master, or by the judge, at his desire, sometimes with crucifixion, amputation of a foot, or by being sent to fight as a gladiator with wild beasts, but most frequently by being branded on the brow with letters indicative of his crime. That severe punishment would be the lot of the recaptured runaway, every one would suppose, from the absolute power of the master to inflict it. That it is inflicted in many cases, it is equally easy and needless to prove. The peculiar forms of punishment mentioned above are now very much out of vogue, but the following advertisement by Mr. Micajah Ricks, in the Raleigh, North Carolina, Standard, of July 18th, 1838, shows that something of classic taste in torture still lingers in our degenerate days. Ran away, a negro woman and 2 children, a few days before she went off. I burnt her with a hot iron, on the left side of her face. I tried to make the letter M. It is charming to notice the naïve betrayal of literary pride on the part of Mr. Ricks. He did not wish that letter M to be taken as a specimen of what he could do in the way of writing. The creature would not hold still, and he fears the M may be illegible. The above is only one of a long list of advertisements of maimed, cropped and branded negroes, in the book of Mr. Weld, entitled American Slavery as It Is, page 77. 13. Cruel masters sometimes hired torturers by profession, or had such persons in their establishments, to assist them in punishing their slaves. The noses and ears and teeth of slaves were often in danger from an enraged owner, and sometimes the eyes of a great offender were put out. Crucifixion was very frequently made the fate of a wretched slave for a trifling misconduct, or from mere caprice. For justification of such practices as these, we refer again to that horrible list of maimed and mutilated men, advertised by slaveholders themselves, in Weld's American Slavery as It Is, page 77. We recall the reader's attention to the evidence of the monster Kephart, given in Part I. As to crucifixion, we presume that there are wretches whose religious scruples would deter them from this particular form of torture, who would not hesitate to inflict equal cruelties by other means, as the Greek pirate, during a massacre in the season of Lent, was conscience stricken at having tasted a drop of blood. We presume? Let any one but read again, if he can, the sickening details that the 12 hours' torture of Southern slaves, and say how much more merciful is American slavery than Roman. The last item in Blair's description of Roman slavery is the following: by a decree passed by the Senate, if a master was murdered when his slaves might possibly have aided him, all his household within reach were held as implicated, and deserving of death. And Tacitus relates an instance in which a family of 400 were all executed. To this alone, of all the atrocities of the slavery of old heathen Rome, do we fail to find a parallel in the slavery of the United States of America. There are other respects, in which the American legislation has reached a refinement in tyranny of which the despots of those early days never conceived. The following is the language of Gibbon: Hope, the best comfort of our imperfect condition, was not denied to the Roman slave, and if he had any opportunity of rendering himself either useful or agreeable, he might very naturally expect that the diligence and fidelity of a few years would be rewarded with the inestimable gift of freedom. Without destroying the distinction of ranks, a distant prospect of freedom and honors was presented even to those whom pride and prejudice almost disdained to number among the human species. Footnote: Gibbon's Decline and Fall, Chapter 2. End footnote. The youths of promising genius were instructed in the arts and sciences, and their price was ascertained by the degree of their skill and talents. Almost every profession, either liberal or mechanical, might be found in the household of an opulent senator. The following chapter will show how the best comfort which Gibbon knew for human adversity is taken away from the American slave; how he is denied the commonest privileges of education and mental improvement; and how the whole tendency of the unhappy system, under which he is in bondage, is to take from him the consolations of religion itself, and to degrade him from our common humanity, and common brotherhood with the Son of God. Part 2, Chapter 12. A comparison of the Roman law of slavery with the American.
Part 2, Chapter 13 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by William Jones. Part 2, Chapter 13, The Men Better Than Their Laws. Start of a Bible verse. Judgment is turned away backward, and justice standeth afar off. For truth is fallen in the street, and equity cannot enter. Yea, truth faileth, and he that departeth from evil maketh himself a prey. Isaiah 59, verses 14 and 15, end of Bible verse. There is one very remarkable class of laws yet to be considered. So full of cruelty and unmerciful severity is the slave code, such an atrocity is the institution of which it is the legal definition, that there are multitudes of individuals too generous and too just to be willing to go to the full extent of its restrictions and deprivations. A generous man, instead of regarding the poor slave as a piece of property, dead, and devoid of rights, is tempted to regard him rather as a helpless younger brother or as a defenseless child, and to extend to him, by his own good right arm, that protection and those rights which the law denies him. A religious man, who by the theory of his belief regards all men as brothers, and considers his Christian slave with himself as a member of Jesus Christ, as of one body, one spirit, and called in one hope of his calling, cannot willingly see him doomed to live without knowledge, without the power of reading the written word, and to raise up his children after him in the same darkness. Hence, if left to itself, individual humanity would, in many cases, practically abrogate the slave code. Individual humanity would teach the slave to read and write, would build schoolhouses for his children, and would, in very, very many cases, enfranchise him. The result of all this has been foreseen. It has been foreseen that the result of education would be general intelligence, that the result of intelligence would be a knowledge of personal rights, and that an inquiry into the doctrine of personal rights would be fatal to the system. It has been foreseen also that the example of disinterestedness and generosity in emancipation might carry with it a generous contagion until it should become universal, that the example of educated and emancipated slaves would prove a dangerous excitement to those still in bondage. For this reason, the American Slave Code, which, as we have already seen, embraces substantially all the barbarities of that of ancient Rome, has added to it a set of laws more cruel than any which ancient and heathen Rome ever knew, laws designed to shut against the slave his last refuge, the humanity of his master. The master in ancient Rome might give his slave whatever advantages of education he chose, or at any time emancipate him. and the state did not interfere to prevent. Footnote 16. In and after the reign of Augustus, certain restrictive regulations were passed, designed to prevent an increase of unworthy citizens by emancipation. They had, however, nothing like the stringent force of American laws. End of footnote. But in America, the laws throughout all the slave states most rigorously forbid, in the first place, the education of the slave. We do not profess to give all these laws, but a few striking specimens may be presented. Our authority is Judge Stroud's Sketch of the Laws of Slavery. The legislature of South Carolina in 1740 enounced the following preamble: whereas having of slaves taught to write, or suffering them to be employed in writing, may be attended with great inconveniences, and enacted that the crime of teaching a slave to write, or of employing a slave as a scribe, should be punished by a fine of £100, current money. If the reader will turn now to the famous protective statute, enacted by the same legislature in the same year, we will find that the same penalty has been appointed for cutting out of the tongue, putting out of the eye, cruel scalding, etc., of any slave, as for the offense of teaching him to write. That is to say, that to teach him to write and to put out his eyes are to be regarded as equally reprehensible. There might be no doubt of the great fundamental policy of the state, and that there might be full security against the great inconveniences of having slaves taught to write. It was enacted in 1800 that assemblies of slaves, free negroes, and so forth, for the purpose of mental instruction in a confined or secret place, and so forth, is or are declared to be an unlawful meeting, and the officers are required to enter such confined places and disperse the unlawful assemblage, inflicting at their discretion such corporal punishment, not exceeding 20 lashes upon such slaves, free negroes, and so forth, as they may judge necessary, for deterring them from the like unlawful assemblage in the future. The statute book of Virginia is adorned with a law similar to the one last quoted. The offense of teaching a slave to write was early punished in Georgia, as in South Carolina, by a pecuniary fine. But the city of Savannah seems to have found this penalty insufficient to protect it from great inconveniences, and we learn, by a quotation in the work of Judge Stroud from a number of the Portfolio, that the city has passed an ordinance by which any person that teaches any person of color, slave or free, to read or write, or causes such a person to be so taught, is subjected to a fine of $30 for each offense, and every person of color who shall keep a school to teach reading or writing is subject to a fine of $30, or to be imprisoned 10 days and whipped 39 lashes. Secondly, in regard to religious privileges, the state of Georgia has enacted a law to protect religious societies in the exercise of their religious duties. This law, after appointing rigorous penalties for the offense of interrupting or disturbing a congregation of white persons, concludes in the following words: "No congregation or company of negroes shall, under pretense of divine worship, assemble themselves contrary to the act regulating patrols." The act regulating patrols, as quoted by the editor of Prince's Digest, empowers every justice of the peace to disperse any assembly or meeting of slaves which may disturb the peace, and so forth, of his Majesty's subjects, and permits that every slave found at such a meeting shall "immediately be corrected without trial, by receiving on the bare back 25 stripes with a whip, switch, or cowskin." The history of legislation in South Carolina is significant. An act was passed in 1800 containing the following section: "It shall not be lawful for any number of slaves, free negroes, mulattoes, or mestizos, even in company with white persons, to meet together and assemble for the purpose of mental instruction or religious worship, either before the rising of the sun or after the going down of same. And all magistrates, sheriffs, militia officers, and so forth, are hereby vested with the power, and so forth, for dispersing such assemblies, and so forth." The law just quoted seems somehow to have had a prejudicial effect upon the religious interests of the slaves, free negroes, and so forth, specified in it. For 3 years afterwards, on the petition of certain religious societies, a protective act was passed, which should secure them this great religious privilege, to wit, that it should be unlawful before 9 o'clock to break into a place of meeting wherein shall be assembled the members of any religious society of this state, provided a majority of them shall be white persons, or otherwise to disturb their devotion, unless such person shall have first obtained a warrant, and so forth. Thirdly, it appears that many masters who are disposed to treat their slaves generously have allowed them to accumulate property, to raise domestic animals for their own use, and in the case of intelligent service, to go at large, to hire their own time, and to trade upon their own account. Upon all these practices the law comes down with unmerciful severity. A penalty is inflicted on the owner, but with a rigor quite accordant with the tenor of slave law. The offense is considered in law as that of the slave rather than that of the master. So that, if the master is generous enough not to regard the penalty which is imposed upon himself, he may be restrained by the fear of bringing a greater evil upon his dependent. These laws are, in some cases, so constructed as to make it for the interest of the lowest and most brutal part of society that they be enforced by offering half the profits to the informer. We give the following as specimens of slave legislation on this subject. The law of South Carolina: "It shall not be lawful for any slave to buy, sell, trade, and so forth, for any goods, and so forth, without a license from the owner, and so forth, nor shall any slave be permitted to keep any boat, periauger, or canoe, or raise and breed for the benefit of such slave any horses, mares, cattle, sheep, or hogs, under pain of forfeiting all the goods, and so forth, and all the boats, periaugers, or canoes, horses, mares, cattle, sheep, or hogs. And it shall be lawful for any person whatsoever to seize and take away from any slave all such goods, and so forth, boats, and so forth, and to deliver the same into the hands of any justice of the peace nearest to the place where the seizure shall be made. And such justice shall take the oath of the person making such a seizure concerning the manner thereof, and if the said justice shall be satisfied that such seizure has been made according to law, he shall pronounce and declare the goods so seized to be forfeited, and order the same to be sold at public outcry, 1/2 of the moneys arising from such sale to go to the state, and the other half to him or them that sue for the same." The laws in many other states are similar to the above, but the state of Georgia has an additional provision against permitting the slave to hire himself to another for his own benefit. A penalty of $30 is imposed for every weekly offense on the part of the master, unless the labor be done on his own premises. Savannah, Augusta, and Sunbury are places excepted. In Virginia, "If the master shall permit his slave to hire himself out," the slave is to be apprehended and the master to be fined. In an early act of the legislature of the Orthodox and Presbyterian state of North Carolina, it is gratifying to see how the judicious course of public policy is made to subserve the interest of Christian charity. how, in a single ingenious sentence, provision is made for punishing the offender against society, rewarding the patriotic informer, and feeding the poor and destitute. Open side quote. All horses, cattle, hogs, or sheep that 1 month after the passing of this act shall belong to any slave or be of any slave's mark in this state shall be seized and sold by the county wardens, and by them applied, the one half to support the poor of the county, and the other half to the informer. Close side note. In Mississippi, a fine of $50 is imposed upon the master who permits his slave to cultivate cotton for his own use, or who licenses his slave to go at large and trade as a freeman, or who is convicted of permitting his slave to keep stock of any description. To show how the above law has been interpreted by the highest judicial tribunal of the sovereign state of Mississippi, we repeat here a portion of decision of Chief Justice Sharkey, which we have elsewhere given more in full. Quote, independent of the principles laid down in adjudicated cases, our statute law prohibits slaves from owning certain kinds of property. It may be inferred that the legislature supposed they were extending the act as far as it could be necessary to exclude them from owning any property, as the prohibition includes that kind of property which would most likely be permitted to own without interruption, to wit, hogs, horses, cattle, and so forth. They cannot be prohibited from holding such property in consequence of its being a dangerous or offensive character, but because it was deemed impolitic for them to hold property of any description. Close quote. It was asserted at the beginning of this head that the permission of the master to a slave to hire his own time is, by law, considered the offense of the slave being subject to prosecution, therefore, not the master. This is evident from the tenor of some of the laws quoted and alluded to above. It will be still further illustrated by the following decisions of the courts of North Carolina. They are copied from the supplement to the U.S. Digest, Volume 2, page 798. Article 139. An indictment charging that a certain Negro did hire her own time, contrary to the form of the statute and so forth, is defective and must be quashed because it was omitted to be charged that she was permitted by her master to go at large, which is one essential part of the offense. Article 140. Under the first clause of the 31st section of the 111th chapter of the Revised Statutes, prohibiting masters from hiring to slaves their own time, the master is not indictable. He is only subject to a penalty of $40. Nor is the master indictable under the second clause of that section, the process being against the slave, not against the master. Article 142. To constitute the offense under Section 32, Revised Statutes, CXI, Article 32, it is not necessary that the slave should have hired his time. It is sufficient if the master permits him to go at large as a free man. Close quote. This is maintaining the ground that the master can do no wrong, with great consistency and thoroughness, but it is in perfect keeping, both in form and spirit, with the whole course of slave law, which always upholds the supremacy of the master and always depresses the slave. Fourthly, stringent laws against emancipation exist in nearly all the slave states. In 4 of the states, South Carolina, Georgia, Alabama, and Mississippi, emancipation cannot be effected except by a special act of the legislature of the state. In Georgia, the offense of setting free any slave or slaves in any other manner and form than the one prescribed was punishable, according to the law of 1801, by the forfeiture of $200 to be recovered by action or indictment. The slaves in question still remaining, to all intents and purposes, as much in a state of slavery as before they were manumitted. Believers in human progress will be interested to know that since the law of 1801, there has been a reform introduced into this part of the legislation of the Republic of Georgia. In 1818, a new law was passed, which, as will be seen, contains a grand remedy for the abuses of the old. In this it is provided with endless variety of specifications and synonyms, as if to let suspicion double lock the door against any possible evasion, that all and every will, testament, deed, whether by way of trust or otherwise, contract or agreement, or stipulation or other instrument in writing, or by parole, made and executed for the purpose of effecting or endeavoring to effect the manumission of any slave or slaves, either directly or indirectly or virtually, and so forth, shall be, and the same are hereby declared to be, utterly null and void. And the guilty author of the outrage against the peace of the state, contemplated in such deed, and so forth, and all and every person or persons concerned in giving or attempting to give effect thereto, in any way or manner whatsoever, shall be severally liable to a penalty not exceeding $1,000. It would be quite anomalous in slave laws, and contrary to the great and fundamental policy of slave states, if the negroes, who, not having the fear of God before their eyes, but being instigated by the devil, should be guilty of being thus manumitted, were suffered to go unpunished. Accordingly, the law very properly and judiciously provides that each and every slave or slaves, in whose behalf such will or testament, and so forth, shall have been made, shall be liable to be arrested by warrant, and so forth, and, being thereof convicted, and so forth, shall be liable to be sold as a slave or slaves by public outcry, and the proceeds of such slaves shall be appropriated, etc., etc. Judge Stroud gives the following account of the law of Mississippi. Quote, "The emancipation must be by an instrument in writing, a last will or deed, and so forth, under seal, attested by at least 2 credible witnesses, or acknowledged in the court of the county or corporation where the emancipator resides. Proof satisfactory to the General Assembly must be adduced that the slave has done some meritorious act for the benefit of his master, or rendered some distinguished service to the state. All which circumstances are but prerequisites, and are of no efficacy until a special act of assembly sanctions the emancipation, to which may be added, as has been already stated, a saving of the rights of creditors and the protection of the widow's thirds." Close quote. The same prerequisite of meritorious services, to be adjudged of and allowed by the county court, is exacted by an act of the General Assembly of North Carolina, and all slaves emancipated contrary to the provisions of this act are to be committed to the jail of the county, and at the next court held for that county are to be sold to the highest bidder. But the law of North Carolina does not refuse opportunity for repentance, even after the crime has been proved. Accordingly, the sheriff is directed, 5 days before the time for the sale of the emancipated Negro, to give notice, in writing, to the person by whom the emancipation was made, to the end, and with the hope that, smitten by remorse of conscience, and brought to sense of his guilt before God and man, such person may, if he thinks proper, renew his claim to the Negro so emancipated by him, on failure to do which the sale is to be made by the sheriff, and 1/5 part of the net proceeds is to become the property of the freeholder by whom the apprehension was made, and the remaining 4/5 are to be paid into the public treasury. It is proper to add that we have given examples of the laws of states whose legislation on the subject has been most severe. The laws of Virginia, Maryland, Missouri, Kentucky, and Louisiana are much less stringent. A striking case, which shows how inexorably the law contends with the kind designs of the master, is on record in the reports of legal decisions in the state of Mississippi. The circumstances of the case have been thus briefly stated in the New York Evening Post, edited by Mr. William Cullen Bryant. They are a romance of themselves. A man of the name of Elisha Brazil, a planter in Jefferson County, Mississippi, was attacked with a loathsome disease. During his illness he was faithfully nursed by a mulatto slave, to whose assiduous attentions he felt that he owed his life. He was duly impressed by her devotion, and soon after his recovery took her to Ohio and had her educated. She was very intelligent, and improved her advantages so rapidly that when he visited her again he determined to marry her. He executed a deed for her emancipation, and had it recorded both in the states of Ohio and Mississippi, and made her his wife. Mr. Brazil returned with her to Mississippi, and in process of time had a son. After a few years he sickened and died, leaving a will in which, after reciting the deed of emancipation, he declared his intention to ratify it, and devised all of his property to this lad, acknowledging him in the will to be such. Some poor and distant relations in North Carolina, whom he did not know, and for whom he did not care, hearing of his death, came on to Mississippi and claimed the property thus devised. They instituted a suit for its recovery, and the case, it is reported in Howard's Mississippi Reports, Volume 2, page 837, came before Judge Sharkey, our new consul at Havana. He decided it, and in that decision declared the act of emancipation an offense against morality, and pernicious and detestable as an example. He set aside the will, gave the property of Brazil to his distant relations, condemned Brazil's son and his wife, that son's mother, again to bondage, and made them the slaves of these North Carolina kinsmen as part of the assets of the estate. Chief Justice Sharkey, after narrating the circumstances of the case, declares the validity of the deed of emancipation to be the main question in the controversy. He then argues that, although according to the principles of national comity, contracts are to be construed according to the laws of the county or state where they are made, yet these principles are not to be followed when they lead to conclusions in conflict with the great and fundamental policy of the state. What this great and fundamental policy is in Mississippi may be gathered from the remainder of the decision, which we give in full. Quote, "Let us apply these principles to the deed of emancipation. To give it validity would be, in the first place, a violation of the declared policy, and contrary to a positive law of the state. The policy of a state is indicated by the general course of legislation on a given subject. And we find that free negroes are deemed offensive because they are not permitted to immigrate or to remain in the state. They are allowed few privileges, and subject to heavy penalties for offenses. They are required to leave the state within 30 days after notice, and in the meantime give security for good behavior. And those of them who can lawfully remain must register and carry with them their certificates, or they may be committed to jail. It would also violate a positive law passed by the legislature expressly to maintain this settled policy and to prevent emancipation. No owner can emancipate his slave but by a deed or will properly attested or acknowledged in court, and proof to the legislature that such slave has performed some meritorious act for the benefit of the master, or some distinguished service for the state. And the deed or will can have no validity until ratified by a special act of legislature. It is believed that this law and policy are too essentially important to the interests of our citizens to permit them to be evaded. The state of the case shows conclusively that the contract had its origin in an offense against morality, pernicious and detestable as an example. But above all, it seems to have been planned and executed with a fixed design to evade the rigor of the laws of this state. The acts of the party in going to Ohio with the slaves, and their executing the deed, and his immediate return with them to this state, point with unerring certainty to his purpose and object. The laws of this state cannot be thus defrauded by their operation by one of our own citizens. If we could have any doubts about the principle, the case reported in 1 Randolph 15 would remove them. As we think the validity of the deed must depend upon the laws of this state, it becomes unnecessary to inquire whether it could have any force by the laws of Ohio. If it were even valid there, it can have no force here. The consequence is that the Negroes, John Monroe and his mother, are still slaves, and a part of the estate of Elisha Brazil. They have not acquired a right to their freedom under the will, for even if the clause in the will were sufficient for that purpose, their emancipation has not been consummated by an act of the legislature. John Monroe, being a slave, cannot take the property as a devisee, and I apprehend it is equally clear that it cannot be held in trust for him. 4 Desons, Republican 266. Independent of the principles laid down in adjudicated cases, our statute law prohibits slaves from owning certain kinds of property, and it may be inferred that the legislature supposed they were extending the act as far as it could be necessary to exclude them from owning any property, as the prohibition includes that kind of property which they would most likely be permitted to own without interruption, to wit, hogs, horses, cattle, and so forth. They cannot be prohibited from holding such property in consequence of its being of a dangerous or offensive character, but because it was deemed impolitic for them to hold property of any description. It follows, therefore, that his heirs are entitled to the property. As the deed was void, and the devisee could not take under the will, the heirs might, perhaps, have a remedy at law. But as an account must be taken for the rents and profits, and for the final settlement of the estate, I see no good reason why they should be sent back to law. The remedy is, doubtless, more full and complete than it could be at law. The decree of the chancellor overruling the demurrer must be affirmed, and the cause remanded for further proceedings." The Chief Justice Sharkey, who pronounced this decision, is stated by the Evening Post to have been a principal agent in the passage of the severe law under which this horrible inhumanity was perpetrated. Nothing more forcibly shows the absolute despotism of the slave law over all the kindest feelings and intentions of the master, and the determination of courts to carry these severities to their full lengths, than this cruel deed, which precipitated a young man who had been educated to consider himself free, and his mother, an educated woman, back into the bottomless abyss of slavery. Had this case been chosen for the theme of a novel or a tragedy, the world would have cried out upon it as a plot of monstrous improbability. As it stands in the law book, it is only a specimen of that awful kind of truth, stranger than fiction, which is all the time evolving, in one form or another, from the workings of this anomalous system. This view of the subject is a very important one, and ought to be earnestly and gravely pondered by those in foreign countries who are too apt to fasten their condemnation and opprobrium rather on the person of the slaveholder than the horrors of the legal system. In some slave states it seems as if there was very little that the benevolent owner could do which would permanently benefit his slave, unless he should seek to alter the laws. Here it is that the highest obligation of the Southern Christian lies, nor will the world nor God hold them guiltless who, with the elective franchise in their hands, and the full power to speak, write, and discuss, suffer this monstrous system of legalized cruelty to go on from age to age. End of Part 2, Chapter 13, The Men Better Than Their Laws. Recording by William Jones. Part 2, Chapter 14 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by William Jones. Part 2, Chapter 14, The Hebrew Slave Law Compared with the American Slave Law. Having compared the American law with the Roman, we will now compare it with one other code of slave laws, to wit, the Hebrew. This comparison is the more important because American slavery has been defended on the ground of God's permitting Hebrew slavery. The inquiry now arises, what kind of slavery was it that was permitted among the Hebrews? For in different nations, very different systems have been called by the general name of slavery. That the patriarchal state of servitude which existed in the time of Abraham was a very different thing from American slavery, a few graphic incidents in the scripture narrative show. For we read that when the angels came to visit Abraham, although he had 300 servants born in his house, it is said that Abraham hasted and took a calf and killed it, and gave it to a young man to dress, and that he told Sarah to take 3 measures of meal and knead it into cakes, and then, when all was done, he himself set it before his guests. From various other incidents which appear in the patriarchal narrative, it would seem that these servants bore more the relation of the members of a Scotch clan to their feudal lord than that of an American slave to his master. Thus it seems that if Abraham had died without children, his head servant would have been his heir. Genesis 15:3. Of what species, then, was the slavery which God permitted among the Hebrews? By what laws was it regulated? In the New Testament, the whole Hebrew system of administration is spoken of as a relatively imperfect one, and is superseded by the Christian dispensation. Hebrews 8:13. We are taught thus to regard the Hebrew system as an educational system, by which a debased, half-civilized race, which had been degraded by slavery in its worst form among the Egyptians, was gradually elevated to refinement and humanity. As they went from the land of Egypt, it would appear that most disgusting personal habits, the most unheard of and unnatural impurities prevailed among them, so that it was necessary to make laws with relation to things of which Christianity has banished the very name from the earth. Besides all this, polygamy, war, and slavery were the universal custom of nations. It is represented in the New Testament that God, in educating this people, proceeded in the same gradual manner in which a wise father would proceed with a family of children. He selected a few of the most vital points of evil practice, and forbade them by positive statute under rigorous penalties. The worship of any other god was, by the Jewish law, constituted high treason, and rigorously punished with death. As the knowledge of the true God and religious instruction could not then, as now, be afforded by printing in books, one day in the week had to be set apart for preserving in the minds of people a sense of His being and their obligations to Him. The devoting of this day to any other purpose was also punished with death, and the reason is obvious, that its sacredness was the principal means relied on for preserving the allegiance of the nation to their king and God, and its desecration, of course, led directly to high treason against the head of the state. With regard to many other practices which prevailed among the Jews, as among other heathen nations, we find the divine being taking the same course which wise human legislatures have taken. When Lycurgus wished to banish money and its attendant luxuries from Sparta, he did not forbid it by direct statute law, but he instituted a currency so clumsy and uncomfortable that, as we are informed by Rollin, it took a cart and a pair of oxen to carry home the price of a very moderate estate. In the same manner, the divine being surrounded the customs of polygamy, war, blood revenge, and slavery with regulations which gradually and certainly tended to abolish them entirely. No one would pretend that the laws which God established in relation to polygamy, cities of refuge, and so forth, have any application to Christian nations now. The following summary of some of these laws of the Mosaic Code is given by Dr. C. E. Stowe, Professor of Biblical Literature in Andover Theological Seminary. 1. It commanded a Hebrew, even though a married man, with wife and children living, to take the childless widow of a deceased brother and beget children with her. Deuteronomy 25:5-10. 2. The Hebrews, under certain restrictions, were allowed to make concubines, or wives for a limited time, of women taken in war. Deuteronomy 21:10-19. 3. A Hebrew who already had a wife was allowed to take another also, provided he still continued his intercourse with the first as her husband, and treated her kindly and affectionately. Exodus 21:9-11. By the Mosaic law, the nearest relative of a murdered Hebrew could pursue and slay the murderer unless he could escape to the city of refuge, and the same permission was given in case of accidental homicide. Numbers 35:9-39. The Israelites were commanded to exterminate the Canaanites, men, women, and children. Deuteronomy 9:12, 20:16-18. Any one or all of the above practices can be justified by the Mosaic law, as well as the practice of slaveholding. Each of these laws, although in its time was an ameliorating law, designed to take the place of some barbarous abuse, and to be a connecting link by which some higher state of society might be introduced, belongs confessedly to that system which St. Paul says made nothing perfect. They are a part of the commandment which he says was annulled for the weakness and unprofitableness thereof, and which, in the time which he wrote, was waxing old and ready to vanish away. And Christ himself says, with regard to certain permissions of this system, that they were given on account of the hardness of their hearts, because the attempt to enforce a more stringent system at the time, owing to human depravity, would have only produced greater abuses. The following view of the Hebrew laws of slavery is compiled from Barnes' work on slavery and from Professor Stowe's manuscript lectures. The legislation commenced by making the great and common source of slavery, kidnapping, a capital crime. The enactment is as follows: quote, "He that stealeth a man and selleth him, or if he be found in his hand, he shall surely be put to death." Close quote. Exodus 21:16. The sources from which slaves were to be obtained were thus reduced to two. First, the voluntary sale of an individual by himself, which certainly does not come under the designation of involuntary servitude. And second, the appropriation of captives taken in war, and the buying from the heathen. With regard to the servitude of the Hebrew, by a voluntary sale of himself, such servitude, by the statute law of the land, came to an end once in 7 years, so that the worst that could be made of it was that it was a voluntary contract to labor for a certain time. With regard to the servants bought of the heathen, or of foreigners in the land, there was a statute by which their servitude was annulled once in 50 years. It has been supposed, from a disconnected view of one particular passage in the Mosaic Code, that God directly countenanced the treating of a slave who was a stranger and foreigner, with more rigor and severity than a Hebrew slave. That this was not the case will appear from the following enactments, which have express reference to strangers. The stranger that dwelleth with you shall be unto you as one born among you, and thou shalt love him as thyself. Leviticus 19:34. Thou shalt neither vex a stranger nor oppress him, for ye were strangers in the land of Egypt. Exodus 22:21. Thou shalt not oppress a stranger, for ye know the heart of a stranger. Exodus 23:9. The Lord your God regardeth not persons. He doth execute the judgment of the fatherless and the widow, and loveth the stranger in giving him food and raiment. Love ye therefore the stranger. Deuteronomy 10:17-19. Judge righteously between every man and his brother, and the stranger that is with him. Deuteronomy 1:16. Cursed be he that perverteth the judgment of the stranger. Deuteronomy 27:19. Instead of making slavery an oppressive institution with regard to the stranger, it was made by God a system within which heathen were adopted into the Jewish state, educated and instructed in the worship of the true God, and in due time emancipated. In the first place, they were protected by law from personal violence. The loss of an eye or tooth, through the violence of his master, took the slave out of that master's power entirely, and gave him his liberty. Then, further than this, if a master's conduct toward a slave was such as to induce him to run away, it was enjoined that nobody should assist in retaking him, and that he should dwell wherever he chose in the land without molestation. Third, the law secured to the slave a very considerable portion of time, which was to be at his own disposal. Every 7th year was to be at his own disposal. Leviticus 25:4-6. Every 7th day was, of course, secured to him. Exodus 20:10. The servant had the privilege of attending the 3 great national festivals, when all the males of the nation were required to appear before God in Jerusalem. Exodus 24:23. Each of these festivals, it is computed, took up about 3 weeks. The slave was also to be a guest in the family festivals. In Deuteronomy 12:12 it is said, Ye shall rejoice before the Lord your God, ye and your sons, and your daughters, and your men servants, and your maidservants, and the Levite that is within your gates. Dr. Barnes estimates that the whole amount of time which a servant could have to himself would amount to about 23 years out of 50, or nearly 1/2 his time. Again, the servant was placed on an exact equality with his master in all that concerned his religious relations. Now, if we recollect that in the time of Moses, the God and the king of the nation were one and the same person, and that the civil and religious relation were one and the same, it will appear that the slave and his master stood on an equality in their civil relation with regard to the state. Thus, in Deuteronomy 29 is described a solemn national convocation, which took place before the death of Moses, when the whole nation were called upon, after a solemn review of their national history, to renew their constitutional oath of allegiance to their supreme magistrate and Lord. On this occasion Moses addressed them thus, quote, Ye stand this day, all of you, before the Lord your God, your captains of your tribes, your elders and your officers, with all the men of Israel, your little ones, your wives, and thy stranger that is in thy camp, from the hewer of thy wood unto the drawer of thy water, that thou shouldst enter into covenant with the Lord thy God, and into his oath which the Lord thy God maketh with thee this day. Close quote. How different is this from the cool and explicit declaration of South Carolina with regard to the position of the American slave. Quote, a slave is not generally regarded as legally capable of being within the peace of the state. he is not a citizen, and is not in that character entitled to her protection. Close quote. In all the religious services, which, as we have seen by the constitution of the nation, were civil services, the slave and the master mingled on terms of strict equality. There is none of the distinction which appertains to a distinct class or caste. Quote, there was no special service appointed for them at unusual seasons. There were no particular seats assigned to them to keep up the idea that they were a degraded class. There was no withholding from them the instruction which the Word of God gave about the equal rights of mankind. Close quote. Fifthly, it was always contemplated that the slave would, as a matter of course, choose the Jewish religion and the service of God, and enter willingly into all the obligations and services of the Jewish polity. Mr. Barnes cites the words of Maimonides to show that this was commonly understood by the Hebrews. Inquiry into the Scriptural Views of Slavery by Albert Barnes, page 132. Quote, whether a servant be born in the power of an Israelite, or whether he be purchased from the heathen, the master is to bring them both into the covenant. But he that is in the house is entered on the 8th day, and he that is bought with money on the day on which his master receives him, unless the slave be unwilling. For if the master receive a grown slave, and he be unwilling, his master is to bear with him, to seek to win him over by instruction, and by love and kindness for 1 year. After which, should he refuse so long, it is forbidden to keep him longer than a year, and the master must send him back to the strangers from whence he came. For the God of Jacob will not accept any other than the worship of a willing heart. Close quote. A sixth fundamental arrangement with regard to the Hebrew slave was that he could never be sold. Concerning this, Mr. Barnes remarks, a man in certain circumstances might be bought by a Hebrew, but when once bought, that was the end of the matter. There is not the slightest evidence that any Hebrew ever sold a slave, and any provision contemplating that was unknown to the constitution of the Commonwealth. It is said of Abraham that he had servants bought with money, but there is no record of his having ever sold one, nor is there any account of it ever having been done by Isaac or Jacob. The only instance of a sale of this kind among the patriarchs is the act of the brothers of Joseph, which is held up to strong reprobation, by which they sold him to the Ishmaelites. Permission is given by the law of Moses to buy a servant, but none is given to sell him again. And the fact that no such permission is given is full proof that it was not contemplated. When he entered into that relation, it became certain that there could be no change, unless it was voluntary on his part, or unless his master gave him his freedom, until the not distant period fixed by law when he could be free. There is no arrangement in the law of Moses by which servants were to be taken in payment of their master's debts, by which they were to be given as pledges, by which they were to be consigned to the keeping of others, or by which they were to be given away as presents. There are no instances occurring in the Jewish history in which any of these things were done. This law is positive in regard to the Hebrew servant, and the principle of the law would apply to all others. Leviticus 25:42. Quote, they shall not be sold as bondmen. Close quote. In all these respects, there was a marked difference, and there was doubtless intended to be, between the estimate affixed to servants and to property. As to the practical workings of this system, as they are developed in the incidents of sacred history, they are precisely what we would expect from such a system of laws. For instance, we find it mentioned incidentally in the 9th chapter of the 1st book of Samuel, that when Saul and his servant came to see Samuel, that Samuel, in anticipation of his being crowned king, made a great feast for him. And in verse 22nd, the history says, "And Samuel took Saul and his servant, and brought them into the parlor, and made them sit in the chiefest place." We read also in 2 Samuel 9:10 of a servant of Saul who had large estates and 20 servants of his own. We find in 1 Chronicles 2:34 the following incident related. Quote, "Now Sheshan had no sons, but daughters. And Sheshan had a servant, an Egyptian, whose name was Jarha. And Sheshan gave his daughter to Jarha, his servant, to wife." Close quote. Does this resemble American slavery? We find, moreover, that this connection was not considered at all disgraceful. For the son of this very daughter was enrolled among the valiant men of David's army. 1 Chronicles 2:41. In fine, we are not surprised to discover that the institutions of Moses, in effect, so obliterated all the characteristics of slavery that it had ceased to exist among the Jews long before the time of Christ. Mr. Barnes asks, on what evidence would a man rely to prove that slavery existed at all in the land in the time of the later prophets of the Maccabees, or when the Savior appeared? There are abundant proofs, as we shall see, that it existed in Greece and Rome. But what is the evidence that it existed in Judea? So far as I have been able to ascertain, there are no declarations that it did to be found in the canonical books of the Old Testament or in Josephus. There are no allusions to laws and customs which imply that it was prevalent. There are no coins or medals which suppose it. There are no facts which do not admit of an easy explanation on the supposition that slavery had ceased. Two objections have been urged to the interpretations which have been given of two of the enactments before quoted. 1. It is said that the enactment, quote, "Thou shalt not return to his master the servant that has escaped," close quote, relates only to servants escaping from heathen masters to the Jewish nation. The following remarks on this passage are from Professor Stowe's lectures. Deuteronomy 23:15 and 16. Those words make a statute which, like every other statute, is to be strictly construed. There is nothing in the language to limit its meaning. There is nothing in the connection in which it stands to limit its meaning. Nor is there anything in the history of the Mosaic legislation to limit the application of this statute to the case of servants escaping from foreign masters. The assumption that it is thus limited is wholly gratuitous, and, so far as the Bible is concerned, unsustained by any evidence whatsoever. It is said that it would be absurd for Moses to enact such a law while servitude existed among the Hebrews. It would indeed be absurd were the object of the Mosaic legislation to sustain and perpetuate slavery. But if it were the object of Moses to limit and restrain, and finally to extinguish slavery, this statute was admirably adapted to his purpose. That it was the object of Moses to extinguish, and not to perpetuate, slavery is perfectly clear from the whole course of his legislation on the subject. Every slave was to have all the religious privileges and instruction to which his master's children were entitled. Every 7th year released the Hebrew slave, and every 50th year produced universal emancipation. If a master, by an accidental or angry blow, deprived the slave of a tooth, the slave, by that act, was forever free. And so, by the statute in question, if the slave felt himself oppressed, he could make his escape, and though the master was not forbidden to retake him if he could, everyone was forbidden to aid his master in doing it. This statute, in fact, made the servitude voluntary, and that was what Moses intended. Moses dealt with slavery precisely as he dealt with polygamy and with war. Without directly prohibiting, he so restricted as to destroy it. Instead of cutting down the poison tree, he girdled it, and left it to die of itself. There is a statute in regard to military expeditions precisely analogous to the celebrated fugitive slave law. Had Moses designed to perpetuate a warlike spirit among the Hebrews, the statute would have been preeminently absurd. But if it was his design to crush it and to render foreign wars almost impossible, the statute was exactly adapted to his purpose. It rendered foreign military service, in effect, entirely voluntary, just as the fugitive law rendered domestic servitude, in effect, voluntary. The law may be found at length in Deuteronomy 20:5-10, and let it be carefully read and compared with the fugitive slave law already adverted to. Just when the men are drawn up ready for the expedition, just at the moment when even the hearts of brave men are apt to fail them, the officers are commanded to address the soldiers thus: What man of you is there that hath built a new house, and hath not dedicated it? Let him go, and return to his house, lest he die in the battle, and another man dedicate it. And what man is he that hath planted a vineyard, and hath not yet eaten of it? Let him also go, and return to his house, lest he die in the battle, and another man eat of it. And what man is there that hath betrothed a wife, and hath not taken her? Let him go, and return to his house, lest he die in the battle, and another man take her. And the officers shall speak further unto the people, and they shall say, What man is there that is fearful and faint-hearted? Let him go, and return into his house, lest his brethren's heart faint, as well as his heart. Now consider that the Hebrews were exclusively an agricultural people, that warlike parties necessarily consist mainly of young men, and that by this statute every man who had built a house in which he had not yet lived in, and every man who had planted a vineyard from which he had not yet gathered fruit, and every man who had engaged a wife whom he had not yet married, and everyone who felt timid and faint-hearted, was permitted and commanded to go home. How many would there probably be left, especially when the officers, instead of exciting their military ardor by visions of glory and splendor, were commanded to repeat it over and over again that they would probably die in the battle and never get home, and hold this idea up before them as if it were the only idea suitable for their purpose? How excessively absurd is the whole statute, considered as a military law, just as absurd as the Mosaic fugitive law, understood in its widest application, is considered as a slave law. It is clearly the object of this military law to put an end to military expeditions. For, with this law in force, such expeditions must always be entirely volunteer expeditions. Just as clearly was it the object of the fugitive slave law to put an end to compulsory servitude. For, with that law in force, the servitude must, in effect, be to a great extent voluntary. That is just what the legislator intended. There is no possibility of limiting the law on account of its absurdity, when understood in its widest sense, except by proving that the Mosaic legislation was designed to perpetuate and not limit slavery. And this certainly cannot be proved, for it is directly contrary to the plain matter of fact. I repeat it then again. There is nothing in the language of this statute, there is nothing in the connection in which it stands, there is nothing in the history of the Mosaic legislation on this subject, to limit the application of the law to the case of servants escaping from foreign masters. But every consideration from every legitimate source leads us to a conclusion directly the opposite. Such a limitation is the arbitrary, unsupported, stet voluntas pro ratione assumption of the commentator, and nothing else. The only shadow of a philological argument that I can see for limiting the statute is found in the use of the words "to thee" in the 15th verse. It may be said that the pronoun "thee" is used in a national and not individual sense, implying an escape from some other nation to the Hebrews. But examine the statute immediately preceding this, and observe the use of the pronoun "thee" in the 13th verse. Most obviously, the pronouns in these statutes are used with reference to the individuals addressed, and not in a collective or national sense exclusively. Very rarely, if ever, can this sense be given to them in the way claimed by the argument referred to. 2. It is said that the proclamation, "Thou shalt proclaim liberty through the land to all the inhabitants thereof," related only to Hebrew slaves. This assumption is based entirely on the supposition that the slave was not considered in Hebrew law as a person, as an inhabitant of the land, and as a member of the state. But we have just proved that in the most solemn transaction of the state, the hewer of wood and the drawer of water is expressly designated as being just as much an actor and participator as his master. And it would be absurd to suppose that in a statute addressed to all the inhabitants of the land, he is not included as an inhabitant. Barnes enforces this idea by some pages of quotations from Jewish writers, which will fully satisfy anyone who reads his work. From a review, then, of all that relates to the Hebrew slave law, it will appear that it was a very well considered and wisely adapted system of education and gradual emancipation. No rational man can doubt that if the same laws were enacted and the same practices prevailed with regard to slavery in the United States, that the system of American slavery might be considered, to all intents and purposes, practically at an end. If there is any doubt of this fact, and it is still thought that the permission of slavery amongst the Hebrews justifies American slavery, in all fairness, the experiment of making the two systems alike ought to be tried, and we should see then what would be the result. End of Part 2, Chapter 14, The Hebrew Slave Law Compared with the American Slave Law. Recording by William Jones. Part 2, Chapter 15 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by William Jones. Part 2, Chapter 15, Slavery is Despotism. It is always important, in discussing a thing, to keep before our minds exactly what it is. The only means of understanding precisely what a civil institution is are an examination of the laws which regulate it. In different ages and nations, very different things have been called by the name of slavery. Patriarchal servitude was one thing, Hebrew servitude was another, Greek and Roman servitude still a third, and these institutions differed very much from one another. What, then, is American slavery, as we have seen it exhibited by law and by the decisions of the courts? Let us begin by stating what it is not. It is not apprenticeship, it is not guardianship, it is in no sense a system for the education of a weaker race by a stronger. The happiness of the governed is in no sense its object. The temporal improvement or the eternal well-being of the governed is in no sense its object. The object of it has been distinctly stated in one sentence by Judge Ruffin: "The end is the profit of the master, his security, and the public safety." Slavery, then, is absolute despotism of the most unmitigated form. It would, however, be doing injustice to the absolutism of any civilized country to liken American slavery to it. The absolute governments of Europe, none of them pretend to be founded on a property right of the governor, to the persons and entire capabilities of the governed. This is a form of despotism which exists only in some of the most savage countries of the world, as for example in Dahomey. The European absolutism or despotism now does to some extent recognize the happiness and welfare of the governed as the foundation of government, and the ruler is considered as invested with power for the benefit of the people, and his right to rule is supposed to be somewhat predicated upon the idea that he better understands how to promote the good of the people than they themselves do. No government in the civilized world now presents the pure despotic idea as it existed in the old days of the Persian and Assyrian rule. The arguments which defend slavery must be substantially the same as those which defend despotism of any other kind, and the objections which are to be urged against it are precisely those which can be urged against despotism of any other kind. The customs and practices to which it gives rise are precisely those to which despotisms in all ages have given rise. Is the slave suspected of a crime? His master has the power to examine him by torture. See the State versus Castleman. His master has, in fact, in most cases, the power of life and death, owing to the exclusion of the slave's evidence. He has the power of banishing the slave at any time, and without giving an account to anybody, to an exile as dreadful as that of Siberia, and to labors as severe as those of the galleys. He has also unlimited power over the character of his slave. He can accuse him of any crime, yet withhold from him all right of trial or investigation, and sell him into captivity with his name blackened by an unexamined imputation. These are all abuses for which despotic governments are blamed. They are powers which good men who are despotic rulers are beginning to disuse. But under the flag of every slaveholding state, and under the flag of the whole United States in the District of Columbia, they are committed indiscriminately to men of any character. But the worst kind of despotism has been said to be that which extends alike over the body and over the soul, which can bind the liberty of the conscience and deprive a man of all right of choice in respect to the manner in which he shall learn of the will of God and worship him. In other days, kings on their thrones and cottagers by their firesides alike trembled before a despotism which declared itself able to bind and to loose, to open and to shut the kingdom of heaven. Yet this power to control the conscience, to control the religious privileges, and all the opportunities which man has of acquaintanceship with his Maker, and of learning to do his will, is, under the flag of every slave state, and under the flag of the United States, placed in the hands of any man of any character who can afford to pay for it. It is a most awful and most solemn truth that the greatest republic in the world does sustain, under her national flag, the worst system of despotism which can possibly exist. With regard to one point to which we have adverted, the power of the master to deprive the slave of a legal trial while accusing them of a crime, a very striking instance has occurred in the District of Columbia within a year or two. The particulars of the case, as stated at the time in several papers, were briefly these: a gentleman in Washington, our national capital, an elder in the Presbyterian Church, held a female slave, who had for some years supported a good character in the Baptist church of that city. He accused her of an attempt to poison his family, and immediately placed her in the hands of a slave dealer, who took her over and imprisoned her in the slave pen at Alexandria to await the departure of a coffle. The poor girl had a mother who felt as any mother would naturally feel. When apprised of the situation of her daughter, she flew to the pen, and with tears besought an interview with her only child, but she was cruelly repulsed and told to be gone. She then tried to see the elder, but failed. She had the promise of money sufficient to purchase her daughter, but the owner would listen to no terms of compromise. In her distress, the mother repaired to a lawyer in the city and begged him to give form to her petition in writing. She stated to him what she wished to have said, and he arranged it for her in such a form as she herself might have presented it in, had not the benefits of education been denied her. The following is the letter. Washington, July 25th, 1851. Mr. Blank. Sir, I address you as a rich Christian freeman and father, while I am myself but a poor slave mother. I come to plead with you for an only child whom I love, who is a professor of the Christian religion with yourself, and a member of a Christian church, and who, by your active ownership, now pines in her imprisonment in a loathsome man warehouse, where she is held for sale. I come to plead with you for the exercise of that blessed law, whatsoever ye would that men should do unto you, do ye even so to them. With great labor I have found friends who are willing to aid me in the purchase of my child, to save us from a cruel separation. You, as a father, can judge of my feelings when I was told that you had decreed her banishment to distant as well as to hopeless bondage. For nearly 6 years my child has done for you the hard labor of a slave. From the age of 16 to 22 she has done the hard work of your chamber, kitchen, cellar, and stables. By night and by day, your will and your commands have been her highest law, and all this has been unrequited toil. If in all this time her scanty allowance of tea and coffee has been sweetened, it has been at the cost of her slave mother, and not yours. You are an office bearer in the church and a man of prayer. As such, and as the absolute owner of my child, I ask candidly whether she has enjoyed such mild and gentle treatment and amiable example as she ought to have had to encourage her in her monotonous bondage. Has she received at your hands, in faithful religious instruction in the Word of God, a full and fair compensation for all her toil? It is not to me alone that you must answer these questions. You acknowledge the high authority of His laws, who preached a deliverance to the captive, and who commands you to give to your servant that which is just and equal. Oh, I entreat you, withhold not, at this trying hour, from my child that which will cut off her last hope, and which may endanger your own soul. It has been said that you charge my daughter with crime. Can this be really so? Can it be that you would set aside the obligations of honor and good citizenship, that you would dare to sell the guilty one away for money rather than bring her to trial, which you know she is ready to meet? What would you say if you were accused of guilt and refused a trial? Is not her fair name as precious to her in the church to which she belongs as yours can be to you? Suppose now, for a moment, that your daughter, whom you love instead of mine, was in these hot days incarcerated in a negro pen, subject to my control, fed on the coarsest food, committed to the entire will of a brute, denied the privilege commonly allowed even to the murderer, that of seeing the face of his friends. Oh, then you would feel soon then for a poor slave mother and her child, and do for us as you shall wish you had done when we shall meet before the great Judge, and when it shall be your greatest joy to say, I did let the oppressed free. Ellen Brown. End of letter. The girl, however, was sent off to the Southern market. The writer has received these incidents from the gentleman who wrote the letter. Whether the course pursued by the master was strictly legal is a point upon which we are not entirely certain. That it was a course in which the law did not in fact interfere is quite plain, and it is also very apparent that it was a course against which public sentiment did not remonstrate. The man who exercised this power was a professedly religious man, enjoying a position of importance in a Christian church, and it does not appear from any movements in the Christian community about him that they did not consider his course a justifiable one. Yet is not this kind of power the very one at which we are so shocked when we see it exercised by foreign despots? Do we not read with shuddering what in Russia or in Austria a man accused of a crime is seized upon, separated from his friends, allowed no opportunities of trial or self-defense, but carried off to Siberia or some other dreaded exile? Why is despotism any worse in the governor of a state than in a private individual? There is a great controversy now going on in the world between the despotic and the republican principle. All the common arguments used in support of slavery are the arguments that apply with equal strength to despotic government. And there are some arguments in favor of despotic governments that do not apply to individual slavery. There are arguments, and quite plausible ones, in favor of despotic government. Nobody can deny that it possesses a certain kind of efficiency, compactness, and promptness of movement, which cannot, from the nature of things, belong to a republic. Despotism has established and sustained much more efficient systems of police than ever a republic did. The late King of Prussia, by the possession of absolute despotic power, was enabled to carry out a much more efficient system of popular education than we ever have succeeded in carrying out in America. He districted his kingdom in the most thorough manner, and obliged every parent, whether he would or not, to have his children thoroughly educated. If we reply to all this, as we do, that the possession of absolute power in a man qualified to use it right is undoubtedly calculated for the good of the state, but that there are so few men that know how to use it that this form of government is not, on the whole, a safe one, then we have stated an argument that goes to overthrow slavery as much as it does a despotic government. For certainly the chances are much greater of finding one man in the course of 50 years who is capable of wisely using this power than of finding thousands of men every day in our streets who can be trusted with such a power. It is a painful and most serious fact that America trusts to the hands of the most brutal men of her country, equally with the best, that despotic power which she thinks an unsafe thing even in the hands of the enlightened, educated, and cultivated Emperor of the Russias. With all our republican prejudices, we cannot deny that Nicholas is a man of talent, with a mind liberalized by education. We have been informed, also, that he is a man of serious and religious character, that he certainly, acting as he does in the eye of all the world, must have great restraint upon him from public opinion, and a high sense of character. But who is the man to whom American laws entrust powers more absolute than those of Nicholas of Russia or Ferdinand of Naples? He may have been a pirate on the high seas, he may have been a drunkard, he may, like Souther, have been convicted of a brutality at which humanity turns pale. But for all that, American slave law will none the less trust him with his irresponsible power over the body and power over the soul. On which side, then, stands the American nation in the great controversy which is now going on between self-government and despotism? On which side does America stand in the great controversy for liberty of conscience? Do foreign governments exclude their population from the reading of the Bible? The slave of America is excluded by the most effectual means possible. Do we say, but we read the Bible to our slaves and present the gospel orally? This is precisely what religious despotism in Italy says. Do we say that we have no objection to our slaves reading the Bible if they will stop there, but that with this there will come in a flood of general intelligence which will upset the existing state of things. This is precisely what is said in Italy. Do we say we should be willing that the slave should read his Bible, but that he, in his ignorance, will draw false and erroneous conclusions from it, and for that reason we prefer to impart its truths to him orally? This also is precisely what the religious despotism of Europe says. Do we say in our vainglory that despotic government dreads the coming in of anything calculated to elevate and educate the people? And is there not the same dread through all the despotic slave governments of America? On which side, then, does the American nation stand in the great last question of the age? End of Part 2, Chapter 15. Slavery is Despotism. Recording by William Jones. Part 3, Chapter 1 of A Key to Uncle Tom's Cabin by Harriet Beecher Stowe. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by William Jones. Part 3, Chapter 1, Does Public Opinion Protect the Slave? The utter inefficiency of the law to protect the slave in any respect has been shown. But it is claimed that precisely because the law affords the slave no protection, therefore public opinion is the more strenuous in his behalf. Nothing more frequently strikes the eye in running over judicial proceedings in the courts of slave states than announcement of the utter inutility of the law to rectify some glaring injustice toward this unhappy race, coupled with congratulatory remarks on that beneficent state of public sentiment which is to supply entirely this acknowledged deficiency of the law. On this point it may, perhaps, be sufficient to ask the reader, whether North or South, to review in his own mind the judicial documents which we have presented, and ask himself what inference is to be drawn as to the state of public sentiment from the cases there presented, from the pleas of lawyers, the decisions of judges, the facts sworn to by witnesses, and the general style and spirit of the whole proceedings. In order to appreciate this more fully, let us compare a trial in a free state with a trial in a slave state. In the free state of Massachusetts, a man of standing, learning, and high connections murdered another man. He did not torture him, but with one blow sent him in a moment from life. The murderer had every advantage of position, of friends. It may be said, indeed, that he had the sympathy of the whole United States. Yet how calmly, with what unmoved and awful composure, did the judicial examination proceed. The murderer was condemned to die. What a sensation shook the country! Even sovereign states assumed the attitude of petitioners for him. There was a voice of entreaty from Maine to New Orleans. There were remonstrances and there were threats, but still, with what passionless calmness retributive justice held on its way. Though the men who were her instruments were men of merciful and bleeding hearts, yet they bowed in silence to her sublime will. In spite of all that influence and wealth and power could do, a cultivated and intelligent man, from the first rank of society, suffered the same penalty that would fall on any other man who violated the sanctity of human life. Now compare this with the trial in a slave state. In Virginia, Souther also murdered a man, but he did not murder him by one merciful blow, but by 12 hours of torture so horrible that few readers could bear even the description of it. It was a mode of death which, to use the language that Cicero in his day applied to crucifixion, ought to be forever removed from the sight, hearing, and from the very thoughts of mankind. And to this horrible scene 2 white men were witnesses. Observe the mode in which these 2 cases were tried, and the general sensation they produced. Here the lawyers, in this case of Souther, coolly debating whether it can be considered any crime at all. Here the decision of the inferior court that it is murder in the 2nd degree, and apportioning as its reward 5 years of imprisonment. See the horrible butcher coming up to the superior court in the attitude of an injured man. See the case recorded as that of Souther versus the Commonwealth, and let us ask any intelligent man, North or South, what sort of public sentiment does this show? Does it show a belief that the Negro is a man? Does it not show decidedly that he is not considered a man? Consider the further horrible principle which, reaffirmed in the case, is the law of the land in Virginia. It is the policy of the law, in respect to the relation of master and slave, and for the sake of securing proper subordination on the part of the slave, to protect the master from prosecution in all such cases, even if the whipping and punishment be malicious, cruel, and excessive. When the most cultivated and intelligent men in the state, formally and calmly, without any apparent perception of saying anything inhuman, utter such an astounding decision as this, what can be thought of it? If they do not consider this cruel, what is cruel? And if their feelings are so blunted as to see no cruelty in such a decision, what hope is there of any protection to the slave? This law is a plain and distinct permission to such wretches as Souther to inflict upon the helpless slave any torture they may choose without any accusation or impeachment of crime. It distinctly tells Souther and the white witnesses who saw his deed, and every other low, unprincipled man in the court, that it is the policy of the law to protect him in malicious, cruel, and excessive punishments. What sort of an education is this for the intelligent and cultivated men of the state to communicate to the lower and less educated class? Suppose it to be solemnly announced in Massachusetts, with respect to free laborers or apprentices, that it is the policy of the law, for the sake of producing subordination, to protect the master in inflicting any punishment, however cruel, malicious, and excessive, short of death. We cannot imagine such a principle declared without a rebellion and a storm of popular excitement, to which that of Bunker Hill was calmness itself. But supposing the state of Massachusetts were so twice dead and plucked up by the roots as to allow such a decision to pass without comment concerning their working classes, suppose it did pass, and become an active, operative reality, what kind of an educational influence would it exert upon the Commonwealth? What kind of an estimate of the working classes would it show in the minds of those who make and execute the law? What an immediate development of villainy and brutality could be brought out by such a law, avowedly made to protect men in cruelty? Cannot men be cruel enough without all the majesty of the law being brought into operation to sanction it and make it reputable? And suppose it were said, in vindication of such law, oh, of course, no respectable, humane man would ever think of taking advantage of it. Should we not think the old state of Massachusetts sunk very low to have on her legal records direct assurances of protection to deeds which no decent man would ever do? And when this shocking permission is brought in review at the judgment seat of Christ, and the awful judge shall say to its makers, aiders, and abettors, "Where is thy brother?" When all the souls that have called from under the altar, "How long, O Lord, dost thou not judge and avenge our blood?" shall rise around the judgment seat, as a great cloud of witnesses, and the judgment is set, and the books are opened, what answer will be made for such laws and decisions as these? Will they tell the great judge that it was necessary to preserve the slave system, that it could not be preserved without them? Will they dare look upon those eyes which are as a flame of fire with any such avowal? Will he not answer, as with a voice of thunders, "Ye have killed the poor and needy, and ye have forgotten that the Lord was his helper"? The deadly sin of slavery is its denial of humanity to man. This has been the sin of oppression in every age. To tread down, to vilify, and crush the image of God in the person of the poor and lowly has been the great sin of man since the creation of the world. Against this sin all the prophets of ancient times poured forth their thunders. A still stronger witness was borne against this sin when God, in Jesus Christ, took human nature and made each human being a brother of the Lord. But the last and most sublime witness shall be born when a man shall judge the whole earth, a man who shall acknowledge for his brother the meanest slave equally with the proudest master. In most singular and affecting terms, it is asserted in the Bible that the Father hath committed all judgment to the Son, because he is the Son of man. That human nature, which in the person of the poor slave has been despised and rejected, scoffed and scorned, scourged and tortured, shall in that day be glorified, and it shall appear the most fearful of sins to have made light of the sacredness of humanity, as these laws and institution of slavery have done. The fact is that the whole system of slave law and the whole practice of the slave system and the public sentiment that is formed by it are alike based on the greatest of all heresies, a denial of equal human brotherhood. A whole race has been thrown out of the range of human existence, their immortality disregarded, their dignity as children of God scoffed at, their brotherhood with Christ treated as a fable, and all the law and public sentiment and practice with regard to them such as could be justified only on supposition that they were a race of inferior animals. It is because the Negro is considered an inferior animal, and not worthy of any better treatment, that the system which relates to him and the treatment which falls to him are considered humane. Take any class of white men, however uneducated, and place them under the same system of laws, and make their civil condition in all respects like that of the Negro, and would it not be considered the most outrageous cruelty? Suppose the slave law were enacted with regard to all the Irish in our country, and they were parceled off as the property of any man who had money enough to buy them. Suppose their right to vote, their right to bring suit in any case, their right to bear testimony in courts of justice, their right to contract a legal marriage, their right to hold property or make contracts of any sort, were all by one stroke of law blotted out. Furthermore, suppose it was forbidden to teach them to read and write, and that their children to all ages were doomed to live without knowledge. Suppose that in judicial proceedings it were solemnly declared with regard to them that the mere beating of an Irishman, apart from any circumstances of cruelty or any attempt to kill, was no offense against the peace of the state. Suppose that it were declared that for the better preservation of subjection among them, the law would protect the master in any kind of punishment inflicted, even if it should appear to be malicious, cruel, and excessive. And suppose that monsters like Souther, in availing themselves of this permission, should occasionally torture Irishmen to death, but still the circumstance should not be deemed of sufficient importance to call for any restriction on the part of the master. Suppose it should be coolly said, "Oh, yes, Irishmen are occasionally tortured to death, we know, but it is not by any means a general occurrence. In fact, no men of position in society would do it, and when cases of the kind do occur, they are indignantly frowned upon." Suppose it should be stated that the reason that the law restraining the power of the master cannot be made any more stringent is that the general system cannot be maintained without allowing this extent of power to the master. Suppose that, having got all the Irishmen in the country down into this condition, they should maintain that such was the public sentiment of humanity with regard to them as abundantly to supply the want of all legal rights, and to make their condition, on the whole, happier than if they were free. Should we not say that a public sentiment which saw no cruelty in thus depriving a whole race of every right dear to manhood could see no cruelty in anything, and had not proved itself wholly unfit to judge upon the subject? What man would not rather see his children in the grave than see them as slaves? What man who, should he wake tomorrow morning in the condition of an American slave, would not wish himself in the grave? And yet all the defenders of slavery start from the point that this legal condition is not of itself a cruelty. They would hold it the last excess of cruelty with regard to themselves or any white man. Why do they call it no cruelty at all with regard to the Negro? The writer, in defense of slavery in Fraser's Magazine, justifies this depriving of a whole class of any legal rights by urging that the good there is in human nature will supply the deficiencies of human legislation. This remark is one most significant, powerful index of the state of public sentiment, produced even in a generous mind by the slave system. This writer thinks the good there is in human nature will supply the absence of all legal rights to thousands and millions of human beings. He thinks it right to risk their bodies and their souls on the good there is in human nature, yet this very man would not send a $50 bill through the post office in an unsealed letter, trusting the good there is in human nature. Would this man dare to place his children in the position of slaves, and trust them to the good in human nature? Would he buy an estate from the most honorable man of his acquaintance, and have no legal record of the deed, trusting to the good in human nature? And if the good in human nature will not suffice for him and his children, how will it suffice for his brother and his brother's children? Is his happiness of any more importance in God's sight than his brother's happiness, that he must be secured by legal bolts and bonds and bars, and his brother's left to the good there is in human nature? Never are we so impressed with the utter deadness of public sentiment to protect the slave as when we see such opinions as these uttered by men of a naturally generous and noble character. The most striking and most painful examples of the perversion of public sentiment with regard to the Negro race are often given in the writings of men of humanity, amiableness, and piety. That devoted laborer for the slave, the Rev. Charles C. Jones, thus expresses his sense in the importance of one African soul. Quote, "Were it now revealed to us that the most extensive system of instruction which we could devise, requiring a vast amount of labor and protracted through ages, would result in the tender mercy of our God in the salvation of the soul of one poor African, we should feel warranted in cheerfully entering upon our work, with all its costs and sacrifices." Close quote. What a noble, what a sublime spirit is here breathed! Does it not show a mind capable of the very highest impulses? And yet, if we look over his whole writings, we shall see painfully how the moral sense of their finest mind may be perverted by constant familiarity with such a system. We find him constructing an appeal to masters to have their slaves orally instructed in religion. In many passages he speaks of oral instruction as confessedly an imperfect species of instruction, very much inferior to that which results from personal reading and examination of the Word of God. He says in one place that in order to do much good it must be begun very early in life, and intimates that people in advanced years can acquire very little from it. And yet he decidedly expresses his opinion that slavery is an institution with which no Christian has a cause to interfere. The slaves, according to his own showing, are cut off from the best means for the salvation of their souls, and restricted to one of a very inferior nature. They are placed under restriction which makes their souls as dependent upon others for spiritual food as a man without hands is dependent upon others for bodily food. He recognizes the fact, which his own experience must show him, that the slave is at all times liable to pass into the hands of those who will not take the trouble thus to feed his soul. Nay, if we may judge from his urgent appeals to masters, he perceives around him many who, having spiritually cut off the slave's hands, refuse to feed him. He sees that, by the operation of this law, as a matter of fact, thousands are placed in situations where the perdition of the soul is almost certain, and yet he declares that he does not feel called upon at all to interfere with their civil condition. But if the soul of every poor African is that of inestimable worth which Mr. Jones believes, does it not follow that he ought to have the very best means for getting to heaven which it is possible to give him? And is it not he who can read the Bible for himself in a better condition than he who is dependent upon the reading of another? And if it be said that such teaching cannot be afforded because it makes them unsafe property, ought not a clergyman like Mr. Jones to meet this objection in his own expressive language? Quote, "Were it now revealed to us that the most extensive system of instruction which we could devise, requiring a vast amount of labor and protracted through ages, would result in the tender mercy of our God in the salvation of the soul of one poor African, we should feel warranted in cheerfully entering upon our work with all its costs and sacrifices." Close quote. Should not a clergyman like Mr. Jones tell masters that they should risk the loss of all things seen and temporal, rather than incur the hazard of bringing eternal ruin on these souls? All the arguments which Mr. Jones so eloquently used with masters to persuade them to give their slaves oral instruction would apply with double force to show their obligation to give the slave the power of reading the Bible for himself. Again, we come to hear Mr. Jones telling masters of the power they have over the souls of their servants, and we hear him say, quote, "We may, according to the power lodged in our hands, forbid religious meetings and religious instruction on our own plantations. We may forbid our servants going to church at all, or only to such churches as we may select for them. We may literally shut up the kingdom of heaven against men, and suffer not them that are entering to go in." Close quote. And when we hear Mr. Jones say all this, and consider that he must see and know this awful power is often lodged in the hands of wholly irreligious men, in the hands of men of the most profligate character, we can account for his thinking such a system right only by attributing it to that blinding, deadening influence which the public sentiment of slavery exerts even over the best constituted minds. Neither Mr. Jones nor any other Christian minister would feel it right that the eternal happiness of their own children should be thus placed in the power of any man who should have money to pay for them. how then can they think it right that this power be given in the case of their African brother? Does this not show that even in the case of the most humane and Christian people, who theoretically believe in the equality of all souls before God, a constant familiarity with slavery works a practical infidelity on this point, and that they give their assent to laws which practically declare that the salvation of the servant's soul is of less consequence than the salvation of the property relation? Let us not be thought invidious or uncharitable in saying that where slavery exists, there are so many causes necessarily uniting to corrupt public sentiment with regard to the slave, that the best constituted minds cannot trust themselves in it. In the northern and free states, public sentiment has been, and is, to this day, fatally infected by the influence of a past and the proximity of a present system of slavery. Hence the injustice with which the Negro in many of our states is treated. Hence, too, those apologies for slavery and defenses of it which issue from northern presses and even northern pulpits. If even at the North the remains of slavery can produce such baleful effects in corrupting public sentiment, how much more must this be the case where this institution is in full force? The whole American nation is, in some sense, under a paralysis of public sentiment on this subject. It was said by a heathen writer that the gods gave us a fearful power when they gave us the faculty of becoming accustomed to things. This power has proved a fearful one indeed in America. We have got used to things which might stir the dead in their graves. But when a small portion of things daily done in America has been told in England and France and Germany and Italy, there has been a perfect shriek and outcry of horror. America alone remains cool and asks, "What is the matter?" Europe answers back, "Why, we have heard that men are sold like cattle in your country." "Of course they are," says America. "But what then?" "We have heard," says Europe, "that millions of men are forbidden to read and write in your country." "We know that," says America. "But what is this outcry about?" "We have heard," says Europe, "that Christian girls are sold to shame in your markets." "That isn't quite as it should be," says America. "But still, what is this excitement about?" "We hear that 3 millions of your people can have no legal marriage ties," says Europe. "Certainly that is true," returns America. "But you made such an outcry we thought you saw some great cruelty going on." "And you profess to be a free country?" says indignant Europe. "Certainly we are the freest and most enlightened country in the world. What are you talking about?" says America. "You send your missionaries to Christianize us," says Turkey, "and our religion has abolished this horrible system." You are all heathen over there. What business have you to talk?" answers America. Many people seem really to have thought that nothing but horrible exaggeration of the system of slavery could have produced the sensation which has recently been felt in all modern Europe. They do not know that the thing they have become accustomed to, and handled so freely in every discussion, seems to all other nations to the sum and essence of villainy. Modern Europe, opening her eyes and looking on the legal theory of the slave system, on the laws and interpretations of law which define it, says to America, in the language of the indignant Othello, "If thou wilt justify a thing like this, never pray more, abandon all remorse, on horror's head horrors accumulate, do deeds to make heaven weep, all earth amazed, for nothing canst thou to damnation add greater than this." There is an awful state of familiarity with evil which the apostle calls being dead in trespasses of sins, where the truth has been resisted, and evil perseveringly defended, and the convictions of conscience stifled, and the voice of God's Holy Spirit bidden to depart. There is an awful paralysis of the moral sense when deeds unholiest and crimes most fearful cease any longer to affect the nerve. That paralysis, always a fearful indication of the death and dissolution of nations, is a doubly dangerous disease in a republic whose only power is in intelligence, justice, and virtue. End of Part 1, Chapter 30. Does Public Opinion Protect the Slave? Recording by William Jones.